Unexpected afternoon, law nerds. It's Wednesday, July 26th, and today my podcast came out covering the Taylor Schabusiness trial. She is doing a two-part trial. We are in the guilt phase, and opening statements started Monday morning. Closing arguments are starting right now. Because I received such incredible feedback from you with regard to my coverage on the podcast, I thought that perhaps we would want to do closing arguments together. You know what's my favorite part of the case? The judge is just getting ready to read the instructions to the jury. I've paused the stream. We're going to do that together. I'm going to speed them up just a little bit, and then we will be all caught up by the time the attorneys start their closing arguments. Closing arguments should be fairly quick. They shouldn't be horrendously graphic. These attorneys have done a really good job throughout this trial of keeping the facts of the trial, even though this is a decapitation case and a dismemberment case. They have done a good job of keeping those facts not over sensationalized, keeping them really as neutral as the facts allow. So we are going to go over the closing arguments today. This jury is probably going to come back fast. I imagine we will be in the next phase of this trial tomorrow morning for coverage. So I already see the questions. Are murder trials usually this quick? Yes. Most of the trials we've covered on this channel have been unusually long, but this testimony from Monday to Wednesday, it's about 2.5 days of testimony. The defense presented one witness that was read in. The defendant chose not to testify, and that was it. So they are getting to closing right now. We're going to go through I'm going to cover the jury instructions because it's the most important part for us to cover, because then we know what the jury has to decide and the ins and outs of what she has to decide. Of course, the defense is going to argue that count 3 can't happen and that we don't really know her mindset. And for a first-degree murder, you have to prove that that was intentional. So that's what's happening. So we are going to do that together. I figured we could. You guys, I ended up being home quickly enough today that I could cover this. I was giving running commentary about the case on the car ride with Dr. B. And I was like, if they go to closing, I really want to cover closing. And here we are today together. Sometimes the universe just works out for you, right? So we're just going to make it happen. And I love covering these things with y'all. This happened very fast. So let's just roll and see what happens to all of you that are like just finished the podcast. I know. We just did it. I haven't even turned my fan on yet. It was wild. Cheryl, I will talk about that when we get a break. I want to make sure we get caught up. There will be breaks. There's been lots of breaks. The jury has ping-ponged back and forth in this trial. I think I look very red. I think it's just because I'm warm, but it might be my light. We'll figure it out. Who cares? We're just streaming. Y'all know what I look like. It's fine. I'm going to roll the intro. We're going to get this going. And that's what we're covering today. We are covering jury instructions and closing argument. Let's go.
Hey there. I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts. Not. Let's get into it.
All right, y'all, here we are. Let's just roll into these jury instructions. I'm going to have to do my other layout so I'm a little smaller to the side and so we can see everybody. All right, let's get going. Let me know how volume is in the chat. Thank you. Let's roll.
Now instruct you upon the principles of law which you are to follow in considering
me. Let's get started. Also me. Let's pause immediately. I have this sped up just a little bit as we go through jury instructions so we catch up to real time.
The evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, pretty good this trial. These alone, guided by your soundest reason and best judgment.
This has been some of the best sound we've had.
If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues
They're
of
like,
fact
we watched the
solely
video,
as you
Your
view
Honor.
the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. In this first phase of the trial, you have heard evidence that dealt solely with the defendant's conduct during the alleged incident. You are to determine only whether the defendant is guilty of the charges of first-degree intentional homicide, mutilating a corpse, and third-degree sexual assault. If you find the defendant not guilty, the trial will be over. If you find the defendant guilty, the trial will proceed to the second phase, where you will determine whether the defendant was not responsible by reason of mental disease or defect. Evidence is, first, the sworn.
I have to make a note on this because it's really an interesting way that they do this jury instruction, where they tell the jurors, if you find her not guilty, you're done here. Like, you're done here. You just get to stop. But if you find her guilty, you have to stay longer. It's a really interesting way this instruction is worded. But the jury was told that they would be here a week. So they know if they come back with a verdict, then they get to decide about any mental disease or defect. And that will be through expert testimony, likely tomorrow. I think the jury will come back with a verdict tonight. So let's keep going.
Testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received,
Phyllis.
whether or not an exhibit goes to the jury room. Third, any facts
really
to which
like
the
this
lawyers
judge a
have
lot.
agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial.
Yes.
The first count of the information in this case charges that, count 1, the above-named defendant on or about Tuesday, February 22nd, 2022, in the city of Green Bay, Brown County, Wisconsin, did cause the death of Shad Therian with the intent to kill that person, contrary to sections 940.01 sub 1 sub a, 939.
With intent to kill is what the defense is going to be arguing here when we look at the elements of this crime. With intent to kill is what the defense is going to have to argue in closing, because they're going to say she didn't intend to do this, Your Honor. This just whoopsie doodle. So that's the intent to kill is a big part of this.
9.62 sub 1 sub c Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. First-degree intentional homicide, as defined in section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you
These are
beyond
the
a reasonable
elements.
doubt that the following two elements were present. First, the defendant caused the death of Shad Therian. Cause means that the defendant's act was a substantial factor in producing
That's not going to be hard.
Second, that the defendant acted with the intent to kill Shad Therian. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that her conduct was practically certain to cause the death of another human being.
In her statements, and there can be accidental homicides. Those are different sections of penal codes. In her statements to police, she said, yeah, I just kept going. Like, yeah, I just kept going. Like, I just wanted to keep going. So on her own statements, I think they'll find the intent to kill. But it's a very simple elements. Like, the jury has to decide that she caused him to die and she intended to cause that, versus like a bar fight where somebody intends to punch somebody else and they fall over, hit their head, and then subsequently died. So that's the difference between intentional and unintentional homicide.
While the law requires that the defendant acted with the intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act.
This is that premeditation element. You have to decide it even in the instant before the act. So her statement, I decided to keep going, is going to meet this element. Like, I decided to keep going. It's, you made that conscious decision to do this and to keep going.
You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by
They don't
itself
have to prove
establish
why
guilt.
she did it.
You should
Just
give it
that
the
she
weight
did
you
it.
believe it deserves under all the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Shad Therian with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. The second count of the information charges that count 2, the above-named defendant on or about Tuesday, February 22nd, 2022, in the city of Green Bay, Brown County, Wisconsin, did 1 sub C of the Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Section 940.11 sub 1 of the Criminal Code of Wisconsin is violated by one who mutilates, disfigures, or dismembers a corpse with the intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime.
And
Before you may find the defendant guilty of this offense,
her behavior cleaning up is what they're going to argue about whether or not part of the dismemberment was to conceal this crime.
the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present. First,
2.
that the defendant dismembered a corpse. Second, that the defendant dismembered a corpse with the intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find out intent. Intent must be found.
Was she trying to hide what she had
from
done?
the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The third count of the information charges that, count 3, the above-named defendant on or about Tuesday, February 22nd, 2022, in the city of Green Bay, Brown County, Wisconsin, did have sexual intercourse with Shad Therian without that person's consent, contrary to sections 940.225 sub 3 sub A and 939.62 sub 1 sub B of the Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Third-degree sexual assault, as defined in section 940.225 sub 3 sub A of the Criminal Code of Wisconsin, is committed by one who has sexual intercourse with another person without consent. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present.
2 elements
First,
only.
that the defendant had sexual intercourse with Shad Therian. Second, that Shad Therian did not consent to the sexual intercourse. Sexual intercourse means any intrusion, however slight, of any part of a person's body or of any object into the genitalia or anal opening of another. Emission of semen is not required.
So that is the legal definition of what sexual intercourse means for this crime, the third-degree sexual assault. For those of you that don't know the facts surrounding that, it is regarding a foreign object. We will hear more about that in closing. How do they know he didn't consent? I see the questions. It happened after death. So that's how. So they're going to talk about it in closing. They're not going to talk about it a ton in closing, I don't think, but the defense is going to argue that count a lot.
Did not consent means that Shad Therian did not freely agree to have sexual intercourse with the defendant. In deciding whether Shad Therian did not consent, you should consider what the defendant said and did, along with all the other facts and circumstances. This element does not require that Shad Therian offered physical resistance. It is immaterial whether Shad Therian is dead or alive at the time of the sexual intercourse. If you are satisfied beyond a reasonable doubt,
the defense wants to argue whether or not him being deceased matters in the scope of this crime, which is why that was added to the jury instruction, because under the law intends this to apply to live victims and to disrespecting a corpse in that way. It's meant to apply both, if that helps.
That both elements of third-degree sexual assault have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. An intoxicated or drugged condition is a defense to criminal liability only if it is involuntarily produced. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants
This
are
is
not
how they're
required to prove
supposed
their
to
innocence.
decide.
The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty, unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair
Chat,
and
I
rational
am
consideration of
grabbing
the evidence or
questions
lack of evidence.
to answer
It means
after
such a
closing,
doubt as would cause a person of
because we'll do
ordinary
Q&A
prudence
after
to
closing.
pause or hesitate when called upon to act in the most important
Get it,
affairs
Jen?
of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt
I like
is
this
not
judge
a
too.
reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt, you are to search for the truth. An information is nothing more than a written formal accusation against the defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection was made. By allowing the testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. During the trial, the court has ordered certain testimony to be stricken. Yes, disregard all stricken testimony.
I don't know if the
An
court
exhibit
struck
becomes evidence
much.
only when received by the court. An exhibit marked for identification and not received is not evidence.
This was a
An
pretty
exhibit received
straightforward
is
trial.
evidence whether or not it goes to the jury room. Remarks of the attorneys are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to
Your
each
Honor,
statement.
excuse
In
me, Your Honor.
evaluating each statement, you must determine three things.
It's on
Whether the statement was actually made
Sir,
by the defendant.
the
Only so
statements
much
are on
of a
video, sir.
statement as was actually
Sir,
made by a person
video,
may be
they're on
considered
video.
as evidence. Whether the statement was actually restated here at trial, and whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all of the other evidence in determining how much weight, if any, the statement deserves.
She was 24 at the time of the crime, 25
The weight of
now.
evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than the testimony of another witness, or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. If you find that the offense charge was committed by the defendant, it is not necessary for the state to prove that the offense was committed on the precise date alleged in the information. If the evidence shows beyond a reasonable doubt that the offense was committed on a date near the alleged date, that is sufficient. It is the duty of the jury to scrutinize and to weigh the testimony of each witness and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based upon the witness's race, national origin, religion, age, ability, gender identity,
These are all
sexual orientation,
standard
education,
jury
income level,
instructions.
or any other personal characteristic. In determining the credibility of each witness
So these
and
are
the
all
weight you give
read
to the testimony of
regularly.
each witness, consider these factors: whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or discredit the testimony. Then, give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony.
I love this
Instead,
language for
you should
them.
use your common sense and experience.
There's no
In everyday
magic
life,
way. There's
you
no.
determine for yourselves the reliability of things
You
people
just
say
have
to
to
you. You should do
figure
the
it
same
out.
thing here.
How do jurors decide?
The defendant in
Figure
a
it
criminal
out.
case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence and under the instructions given to you by the court. We're now ready for the attorneys to give their closing arguments. I want to speak briefly, however, to both the attorneys that are giving the closing arguments, if you could approach.
They're approaching. These closing arguments should be pretty straightforward. I can't imagine more than 15 minutes per attorney. These are going to be short. There's not much to say. The prosecution doesn't need to bang on about much, and the defense is going to be like, you can't hold the fact that she didn't testify against her, and you need to keep an open mind, and there's no intent. They haven't proven intent. I think that's what we're going to get from the defense.
Ladies and gentlemen, in the event you were wondering, you are going to get a copy of these instructions during your deliberations, because I know they're lengthy. Having said that, Mr. Saunders, are you prepared to give a closing argument? Yes, sir.
All right. And to the prosecution's closing argument.
I want to start with something that we heard yesterday, or actually Monday, during opening statements.
Start with apologizing
Counsel
to making them look at the crime scene photos. Start with an apology. Jurors, you have seen a lot. And thank you for your civic duty. I'm going to turn this up just a little bit for closing because they're going to wander away from the microphone, as lawyers do. I wandered everywhere during closing. I would have been hosed having to be on a mic because I was just all over the place. All right.
Told us that there's always two sides to every story, and with all due respect, this is not one of those stories. This is a story that pretty clearly shows.
I need to see the judge's face. Can we get a
It's a
cut of
story
the
of a
prosecutor and not the
The
judge?
defendant taking
That'd
a dog collar that was around her friend's neck and
Should be great.
pulling it so hard and for so long and with such force that it caused his death. That in that moment, she made a deliberate choice to end her friend's life.
Intent.
She then, after the fact,
Murderous intent. There you go.
degrades his body, engages in sexual acts with him.
He
It's a
does.
story of the defendant
I get
then
that.
dismembering him.
Got to get your steps in.
and leaving his remains all over the house where they were found. And this isn't the state's story. This isn't law enforcement's story. It's the defendant's story, as you heard today, right? So as we go through this, it's easy to sit here and say, yes, the defendant confessed, and it's true. She confessed to every single element that you will see that the state needs to prove. But we
I
didn't
just don't need to see the judge's face. I want them to put the prosecutor in the big box
Called it a day.
and just side by
But you should
side the
expect more,
prosecutor
right?
and
We have the burden
defendant.
of proof, and
That's all we
obviously
need.
Called a number of witnesses to establish what this story shows. So I want to walk through that story. And I know there's a lot of law that was just read to you, but I'm a visual learner, so I like to see kind of what we're looking at here.
Me
So as I
too.
go through these three offenses, there's really, as you'll see, 6 things the state needs to prove beyond a reasonable doubt.
I thought
Not
he
every
looked like
fact
James
that was
Gordon as well.
testified to, not what time.
He's going to show them the
It's not
elements. There's
almost
only
the
2
end of the night.
elements, but he's going to
6
show them
elements
the
for what the state needs
elements.
to prove to you beyond a reasonable doubt. Okay. So first, count 1, first degree intentional homicide. First, that the defendant caused the death of Shad and that she.
By the way, the fact that there are only 2 elements to each of these crimes is so blissfully simple. Some crimes, when you're getting into 5 and 6 elements, it gets very confusing to explain to jurors. This is just, did you cause the death? Did you mean to? It's just so much simpler.
Second, acted with intent to kill him. Okay. And again, as I already mentioned, as we go through these elements, you heard earlier
I'm still
this
sped
morning
up a little.
that the defendant is acknowledging every element that we hear. Okay. Independent of the information you heard today, with the investigation you heard, the DNA, the other information, Dr. Tranquita's testimony, I would argue would prove all these elements as well. But you have on top of that the defendant's admissions to all these elements. Okay. So the defendant caused the death of Shad. And that should be fairly clear here. Obviously, she admits that. You heard Dr. Tranquita's testimony of how Shad died.
Sorry, Your Honor.
Death, strangulation, excessive force being placed on the neck.
I don't know if we need to see it.
That was the sole cause of death that we heard. So let's talk about intent, right?
Maybe we do.
That admittedly, sometimes is a tricky topic, right? We can never know anyone's intent truly. And as you're told, you're not going into the mind of somebody, right? Kind of looking at all the facts and circumstances that you see. In this case, you have the benefit of the defendant opening up her mind to you and telling you what her intent was here.
That's true. She
you also have
told
other
the
signs,
police.
Right? So what does intent mean? That somebody had the mental purpose to do something, right? Some volition. Or that they're aware that what they're doing is practically certain to cause that result, right? And
she said it.
Really, from the defendant.
Just tell them what she
I
said.
want to walk through that because there's a lot of points in that interview where the defendant is telling you exactly what her intent was.
Yeah, just use her statements.
Right. His face was turning purple, right? She describes that and how he's coughing up blood. And you know that's accurate, right? Because you heard Dr. Tranquita's testimony. You saw those photographs.
Sorry about that, by the way.
She's seeing that in person. And yeah, what does she say? I still didn't stop. No, she felt a heartbeat at one point, right? She talks about feeling his heartbeat, and she kept pulling more, and he wouldn't die. And I just wanted him. I was like, damn, right? She admits even that
he wouldn't die, and she was like, damn.
Back, right?
Well,
I heard from Dr. Tranquita as well about how it looked like at one point there were signs of that, where the collar slipped up along the tongue. She's telling you, I was waiting for him to die. I liked it. She figured I'm already this far, and she's pantomiming the act. It's like she's starting a lawnmower. That's how hard she's pulling on this chain, right?
In
her 3 to 5
her
minutes, she thinks. And again, that's consistent with Dr. Tranquita, right?
3 to 5 minutes.
This is not an accident. This isn't a whoops. This is an intentional act.
I appreciate
right?
that he
You don't
didn't
need
say
to prove that
whoopsie
she
doodle.
went to that house with this intent, right? We talked about that in voir dire. We kind of talked through that concept of how, as you're instructed, intent can be formed in the instant before an act, the instant before the pull of a trigger, the instant in this case.
For those of you talking about pulling, she had
go further
and
pull on this chain so hard,
chain dog
that
choke
it causes
collar
the result that we saw in chat.
that has like the 2 different rings.
So we have.
So she was pulling the back ring of a
from the defendant's own mouth.
dog chain
consistent
choke
with everything
collar.
else we're seeing in the case. But you also have Detective Kemp asking her, in that moment, did you kind of realize if you kept pulling on that chain that he would die? She's like, probably, yeah. Yeah, she was aware of that, right? So that goes to this kind of the second either or part of intent, right? Was aware that her conduct was practically certain to cause that result, and it's probably obvious as you sit here of what's going to happen when you're pulling a metal chain like that hard for that long, seeing the result of what's happening to another person, that is going to be the result, right?
You know
So-
that's the result.
You're told you can't look into a person's mind. The defendant told you exactly what her intent was in this case. But as I mentioned, you also have other indicators, right? You have Dr. Tranquita's testimony describing the amount of force that would need to have been done to cause the injuries that he's observing, right? Down to the inner neck muscles, and he's talking about how strong and thick those neck muscles are, and there was hemorrhaging that deep. That's how hard and how long, how much injury the defendant was causing, right? This isn't an accident. If it's an accident, you're not going forward. You're not seeing this result.
You're not spending 5 minutes trying to do
keep
this.
pulling, you're calling for help, you're stopping. You're certainly not after the fact, after you finally finish, then cutting up his body, right? You have all the evidence in this case points to intent, right? You have her acts after the fact, like I said. If this was an accident, something happens, right? You call for help, and you have the exact opposite. You have the defendant cutting him up and cleaning up, getting rid of the remains, pouring it down the shower. We heard a lot of testimony about that. Kind of wiping up with the Clorox wipes, which the defendant is acknowledging as well. So you have the defendant's statement in the case, and it lines up with everything else in the case, right? Even little facts that she's remembering and telling you about, right? The timeline of the February 21st night, right? We heard from A.J. Gannon. You heard the stipulated testimony from Mr. Tomes. You heard from Mike Therian. It's all consistent. Yeah, they were coming and going.
Yep.
You then heard from Steve Hendricks about, they got back sometime in the early morning, and I let them in. Defendant's telling you that same thing. Steve is talking about how at one point during the day on the 22nd, she comes up and asks for her eyeglasses. We heard the defendant talk about that as well. We heard Detective Graff testify about that. So everything she's saying is consistent with what we're objectively seeing, what law enforcement is finding. And in some respects, the defendant's leading the investigation, right? Because when they get there, when law enforcement gets there, we saw Officer Wanish's body cam. We heard from Detective Scanlon and even Dr. Tranquita about how it was really hard to determine what exactly happened when they first got there. And all that information is being provided by the defendant. Okay. So it's an intentional act. She had the mental purpose. We heard about that. It's not, as I talked about, it can be formed at any time before the act, right? It doesn't need to be premeditated. That's not the law in the state. And it's really important, too, to not confuse this with motive, right? We heard evidence about motive, right, and her interest in Jeffrey Dahmer and all that entails. But intent doesn't mean motive. This is what intent means, and we proved intent, right? She
the
causes
judge
that
made a face.
and she told you as much. So those are the two elements. Those are the two things the state needs to prove beyond a reasonable doubt. Count two, mutilating a corpse. So again, there's two elements for this crime. First, the defendant dismembered a corpse. Second, did so with the intent to conceal a crime. So the first element, I think, is pretty clear, right? And we heard extensive testimony from many people, and we saw Dr. Tranquita's diagrams, and obviously I can't imagine this element is going to be in dispute, right? And so again, though, we have this concept of intent, the purpose to conceal a crime, right? And
I think
as you're instructed,
conceal a
use your
crime
common sense.
intent
Like,
is
why is somebody going to this
a strong
length?
argument.
Not only cutting up a body, we heard from Dr. Tranquita about the multiple start and stop kind of signs, the total evisceration of Shad, bagging him into other bags and attempting to carry out. Like, that's the intent, right? We use our common sense that's why you're doing that. But again, she was asked about this, the defendant. And remember in that February 28th interview, the second interview with Detective Groff and Detective Scanlon, she's saying exactly what her intent was, right? It was because there's other people in the house. Like, what am I going to do? Leave the body and have Mom find it?
What am I going to do? She was trying to get him out of the house, and then
again, this was her intent, and it's
got tired and forgot part of him. But she tried to hide him.
Okay.
All of his
third degree
the victim's remains were concealed.
Had sexual intercourse with Shad and did so without consent. So let's talk about the first part. Sexual intercourse is defined in the state as inserting any object into the.
This is going to be a little more graphic, but it shouldn't be hyper graphic. If you guys have been watching this trial, it's not going to be
contact with the penis. We heard about both, right?
More graphic than the testimony.
The dildo in Chad's anus after she killed him. She's talking about how she was sucking on his penis, and there were other phrases used.
Prosecutors tend to tamp that down a bit.
So again, we have for both elements here.
Yes, the prosecutor totally looks like James Corden.
And we heard from Mr. Scott, didn't we? We heard from Mr. Scott about the DNA testing that was done.
Hey, Joe, yes,
some of the
this
reasons
too.
Why, even though the defendant's DNA is on that dildo in Shad's house, Shad's DNA wasn't found on there, and nothing excludes that possibility. And again, everything the defendant's telling you is consistent with other things you're seeing. So there's no reason to believe, a reasonable hypothesis to believe, that she's not also telling you what's happened in this case too, right, for this count. And the second element, did not consent. I mean, that, as you're instructed, is kind of inferred by the fact that at the time that the defendant's telling you she's engaging in these acts, that Shad's deceased, right? So he's not in a position to consent. Okay. So those are the two elements for count three. So in total, 6 elements for the 3 offenses. And again, you're given a lot of law on how to assess credibility of witnesses.
Members of the public are sitting in the courtroom.
Really, you kind of just use your common sense as jurors.
But I don't know if he has any relation to
nothing in the case to
anyone in the court.
Saying, right? So you have the defendant's admissions, as I mentioned earlier. There's other evidence that kind of just only should bolster the conviction in the defendant's guilt. Right? We heard from Kevin Scott, who heard or testified about the DNA testing he did. Shad's blood on the defendant's hands, on her clothing, on the sweatpants.
He's going into
the knives that were found that had Shad's blood on them.
Evidence more than I thought he would, truly.
Even absent her confession, I mean, there's ample evidence here to convict on all 3 counts.
There is no charge of cannibalism here. I keep seeing that pop up into the chat. No, he was talking about oral sex. When he mentioned that briefly, he was talking about oral sex. That is part of that third-degree sexual assault charge. So no, there's no evidence of that here. There is not charged here. The charges are just the murder, the dismembering of the corpse, and the third-degree sexual assault. Those are the 3 charges here. No, there's no facts that support it. So that's what it is. Those are the 3 things. That is all. So that's it. But that's what they're arguing. Let's keep going.
We have many witnesses coming in to talk about the integrity of the investigation, how law enforcement didn't just take the confession and go home, right? We do more, right? Send things in for DNA. We speak with other witnesses. We corroborate the defendant's timeline of things. You heard all that. And that's really important, right? We have the burden of proof. We talk about that, and we embrace that burden of proof. You should hold us to that standard as the state to prove something beyond a reasonable doubt. And that's why we call people from Madison to come up to talk for 5 minutes about, yeah, I received this piece of evidence, and it was fine. And I returned that piece of evidence, and it was fine. Right? Because it's important. We want to show that law enforcement did a thorough investigation in this case. And they did. Because we have the burden of proof. You're instructed on what the burden of proof is and what it's not, right? It's a reasonable doubt. A reasonable hypothesis consistent with guilt, consistent with innocence, you should find the defendant not guilty. You're not searching for doubt. You're ultimately searching for the truth.
Much
so
else there.
Even if it's a heavy burden, doesn't mean the decision is difficult in cases.
It doesn't have to be difficult.
You are instructed not to search for doubt. You're to search for the truth. And there's not a reasonable hypothesis in this case consistent with the defendant's innocence.
She told them what she did.
Right. There's one truth in this case. There's one side of the story. And it happens to be the defendant's story as well, but it's consistent with everyone else's story. It's because that story is
deliberation's going to be pretty fast.
The defendant did to her friend Shab. Based on that, we would ask that you return guilty verdicts on all 3 counts. Thank you.
I said the closing was going to be fast. I've got this sped up a little bit, but I said the closing was going to be pretty fast. He really went through the story. He also has a rebuttal. The pattern for closing is that the prosecution does the closing, then the defense does their closing, then the prosecution can do a rebuttal just to address what the defense brought up because they have the burden of proof. So he will probably do another, he will do a rebuttal after that. So let's see what the defense has to say. It's going to be a lot of, she has a right not to testify. You can't hold that against her. He'll probably talk about that third-degree sexual assault a bit more and saying, you know, nobody saw her do it, so there's no eyewitnesses. We'll see what else he has to say. Let's keep going.
Yes, I am, Your Honor. Thank you.
Yeah, the openings were very quick. There's not a lot. I mean, there's not a lot to say.
Ladies and gentlemen of the jury, Mr. Saunders. Well, as the attorney for the defendant, Taylor Denise Schabusiness, I'd like to share with you that
you pull the microphone to your face. Hold on. We're going to turn this up just a little bit. And then we'll get to Q&A after this.
This case is a puzzling, unclear, confusing, and bizarre set of facts.
Sir, I appreciate you saying that to this jury with a straight face during your argument. It is confusing that somebody would do this, but the rest of it's not very puzzling. She told the police what happened. Why is confusing?
It is unknown what really happened between February 22nd of 2022 and February 23rd of 2022.
Sir, I appreciate you doing your job.
What we do know in this case is that numerous law enforcement officers testified.
Sir,
detectives,
he's trying.
Police officers.
This man is doing his job.
Dr. Kita, and
when we talk about it being difficult to be a defense attorney, when you watch the defense attorneys that talk about cases on YouTube, Ian Runkle's a defense attorney, Natalie Lawyerchick's a defense attorney, there are others who are criminal defense attorneys, and they talk about the difficulty of their job. Today is you getting to watch this man having a difficult day at work because he has to get up and explain to this jury, even though his client said all that she did to law enforcement on video and that was played for the jury, he still has to get up and do his job. So that's what it is. And she did attack her last attorney. She seems to have a good relationship with this one. So he's also trying to maintain that relationship, and he is doing his job ethically.
DNA experts, forensic specialists, lots of different people, some citizen witnesses. I'd ask that you consider setting aside your emotions and decide this case based on the facts that are presented.
Sir, the facts don't help your client either.
You've sat here for the last 3 days. You've been here in court. I know that you've listened very closely, but don't assume anything. When you deliberate about all of the facts.
Sir, they're going to deliberate on those verdict forms, and that's about it.
Law enforcement officers on February 23rd.
Pull the mic to your face.
Went to 829 Stony Brook, Lane in Green Bay, this small Cape Cod home, and made contact with the occupants, Tara Pakinich, Stephen Hendricks, and
this is probably the best sound we've
was
had on a
woken up, but
trial,
they were all
though.
Sitting at the kitchen table, and
So there's that.
officers came in to see what was going on. There was a concern, obviously, that there was a bucket down at the end of the stairs.
Yeah.
And we heard from Detective Roth that this was an ongoing investigation, law enforcement. They were trying to piece this together. It was an unusual situation. And so they were trying to find out what happened. Unfortunately, I believe it was Officer Plonky and Officer Lonish, they testified, they came here and indicated that they went down to check out what was in the basement, and there was the head of Shad Thurian in that black fleet farm bucket. And the investigation continued on. What I submit to you, ladies and gentlemen, is that there really are no eyewitnesses as to what really happened down in the basement.
Sir, there weren't eyewitnesses. There were two people in the basement. One told the police what happened, and the other one is dead. So, yes, there's no eyewitnesses. However, she told police what happened. So there's a confession, though there aren't eyewitnesses. Did she smirk? She's been doing that throughout trial. So yes, there is a confession, but there are not eyewitnesses. I like that he's focusing on the things he can argue.
There's no Taylor Schabusiness there, no other people there. And so
it seems that she's looking at the jury well, making those
then,
faces.
Law enforcement realized that there was a secondary scene, and that was at 2353 Eastman Avenue, apartment 1 in that parking lot. And you saw the video. The officers, I think it was Officer Garth Russell.
He's a wanderer. Somebody just went, microphone. I don't know who in the courtroom told him to get back to his microphone, but somebody's like, back to the microphone.
Thank you. The officers walked up and they parked a distance away, and they walked up in the snow, and they saw a line of cars.
We're going to talk about that at questions.
Apartment complex.
We're going to talk about
and
that.
And they saw a minivan. It was a gold Town and Country Chrysler minivan, and that was a vehicle of concern. Had some snow on the back windshield. There were vehicles.
She's like, not my minivan. I took it from my neighbor. No, her roommate. It was her roommate's minivan.
They saw some lights on the van, and then they saw someone come out the front door, and it was my client. It was Taylor Schabusiness. At that point, she was arrested by Officer Russell, and another officer then realized there was a male inside of the apartment number 1 down the hall. Ended up being Scott Tomes. And he was told to lay on the ground and held at gunpoint, and then he was arrested. So 2 people were taken from the apartment building and taken down to the police station. There was a search of the Eastman Avenue apartment. We don't have any body parts there. I would submit that there really wasn't anything of evidentiary value there.
She was there, covered in the victim's blood.
And
so
that was that. Later on, officers and detectives realized that minivan was something that they were concerned about, so that was taken down to the police storage garage. And then we found out that from Dr. Tranquillo.
After they found remains in the car, it was determined to need to go to impound.
And some of the other forensic specialists, Andre, I believe it was investigator Andre, and Zarnecki. And so they donned Tyvek gear, protective PPE equipment, and they methodically investigated the back of the minivan, and they found the crock pot box that was in a laundry basket sitting on a seat, and there were
A
human remains
box
in there.
in a basket on the
Nobody
seat
saw
with remains.
Taylor Schabusiness driving this minivan. So
he's just
these are
saying-
some of the facts that you got to
He's
think
just
about.
saying nobody knows
Don't
who
rush to
drove it.
judgment, but talk about it, analyze it.
He's doing his
As
job.
jurors, you have to analyze the facts that you hear, and you have to apply the law that the judge gives you. It's a daunting task.
It is a daunting task in a lot of cases. This case,
So then
though,
we hear, you saw the video, the interview between Detective Groff and my client, Taylor Schabusiness. She was taken down to the Green Bay Police Department. Photographs were taken of her, and clothes were taken, and she was put in a yellow suit and then later a blue suit, but she was asked questions. And you got to remember what she said and what questions were being asked. She did say during the interview, "I can't think right now. I'm effing nuts." She said that she was up all night, that the body would rebuild itself. She said weird, odd things.
She was up all night when she was interviewed because police showed up after 3 a.m. She had been up all night with, the killing, and then was interviewed by police. So he is trying to help the jury find some doubt. It's not going to work. I think it's going to keep their mind towards the next phase of the trial, if anything.
Consider her credibility. Consider what she says. Consider what she said to Detective Groff or Detective Scanlon. She said stuff, I would submit that she said things that didn't make sense. She says, I have no idea to some of the questions that the detectives asked her. You remember seeing the video on the screen. I'd ask that you recall that
Don't ask them
she
to
had
recall the
inappropriate
video.
laughs, inappropriate smiling, odd responses. I would submit that she indicated that she did not have sex. She did not have penis to vagina intercourse with Schabusiness. She indicated that she came to the
Sir, that's not what the law requires.
residence and they went downstairs, and within 5 minutes they got to it, whatever that means. She talked about, during the interview with Detective Groff, rebuilding muscle or rebuilding into muscle. Sometimes she wasn't responsive. She talked about hearing gunshots, but I believe Detective Groff said that there were no gunshots in the area of Stony Brook. Eastman Avenue was some other place. She said she was paranoid. She said weird things like, I don't like open spaces. I don't like open spaces.
She's looking like the fuck
No
I
clothes
did.
came off.
Which is
No
it is.
kissing.
She's like,
She said that she allegedly put the dildo into Mr. Therian's backside.
he's going to have to
his anal
deal
area.
with this.
There's no DNA.
His argument is that she said it, but she
We
didn't
heard
do
from
it.
Kevin Scott.
He doesn't have
DNA
much
expert.
to back that up at this point,
He must
though.
have done real well in school, in chemistry and all that. But
The lawyer's always commenting on the scientists. In almost every trial we've watched, the lawyers always somehow are commenting on the scientist. Always like, oh, he must have gone to a lot of school. Stop it! Are you all repressed scientists? Stop it. He probably did do really well in school. What is happening? Stop it. She also was just like, really? Like, sir, just stop it. Look, you're a lawyer. Math and sciences were probably not for you. A lot of us take the LSAT for that reason. We don't shade you about it. Stop it.
the swab from the dildo, item J1, it says the possible contribution of DNA from Schabusiness is inconclusive due to the complexity of the mixture. I would argue that his DNA is not on the dildo. So I would argue that even though the state is charging out third-degree sexual assault, there is no shred of evidence to support that particular charge.
Except that she said she did it. But his argument is really against this charge. The other charges are going to be much harder, and the jury might come back on that. But I don't know.
And I'd ask that you take that into account.
Yeah, you got to argue with what you've got.
No evidence at the Eastman Avenue apartment.
Complexity of the mixture is what
When
they
Detective
said. Thank you,
Roth
Rob.
had my client come down to the Green Bay Police Department with Detective Kevin Kempf. They were talking with her for a while. The interview was maybe 3 hours or so. And then they took a break because Miss Schabusiness had cuts on her thumb, scratches on her palms, other cuts on her fingers. Some of them were deep. You saw the pictures because I believe they were published. And she was taken over to St. Vincent's Hospital for medical evaluation. I would submit that the blood on her hands may have been her own because of the deep cuts that she had suffered or that she had.
From what? What were the deep cuts coming from?
The defense had subpoenaed Mr. Scott Holmes. He was unavailable, and he gave an account of that night. And he had indicated, at least on Monday night, that would have been February 21st, that Taylor Schabusiness and her friend Shad came over. He had seen Shad before, but didn't know his name. And then he thought that they hooked up to do meth.
Kelly, yeah, the cuts on her hands are from the knives that she used.
And he talked about that Taylor Schabusiness had used his vehicle in the past, then didn't get permission on that particular night. Then he indicated that he was drinking. And then he indicated that Taylor Schabusiness returned to his house around midnight with his vehicle, went to her bedroom, and he had a suspicion that she may have been high on drugs. And then he had indicated that Taylor had the bedroom and that he would sleep in his chair. So that's, something else that you have to think about.
This attorney has nothing else to do. There's nothing else he can do
from
other than protect her constitutional rights because of the depth of the statement she gave to law enforcement.
And that he was doing some investigating, and he wasn't sure if Taylor Schabusiness was a suspect
doing the best job he can in the circumstances that were handed to him.
An ongoing new investigation. So that's something you have to take into account as well. The state brought up some photographs, a picture of Taylor with
this case is a reminder of why meth is bad and the Fifth Amendment.
Young girls I submit they like their phones. So do all kids, young people. They like their phones and they look up things on the internet for a variety of different reasons: shock value, curiosity.
Where are you going with this?
But we have a situation here where Taylor did do some searches about Jeffrey Dahmer. I would submit that that's a ruse. that doesn't necessarily mean anything, and that people
is he going to start arguing? These girls, they like their true crime. Sir? Are we going to the true crime angle? These ladies with their phones and their true crime is that oh dear.
Search the internet for all kinds of things on the internet, and that it's for shock value. So that shouldn't really play any part in this case.
Who was she trying to shock with her internet searches? Like, who is she shocking with these internet searches except the jury, who are also not shocked at this point? Is anyone shocked? Not shocked at all.
I would ask that you discount that and set that aside.
Oh God, my search history is horrific, Chad. Most of it's related to these cases.
I would argue that I would argue that it's not
the rest
a clear
of it's
case
related
here.
to shopping.
Was this an accidental death? Did Taylor Schabusiness kill Shad Therian? Was there intent to kill Shad Therian?
Real hard to argue accidental death.
Did Taylor Schabusiness have the mental purpose to kill Shad Therian?
With the amount of time.
Different theories, different things for you to think about. You are all like analysts. You have to assess and decipher the facts. The facts here are very complicated, confusing, unclear.
Sir, you can keep saying that the facts here are complicated, confusing, and unsure, and I think it's a good argument if you can get one juror to doubt and be like, oh, this isn't as simple as it seems. Maybe he is trying with everything he can to do his best, but the facts here are not complicated or confusing but he is trying to get that one juror. He is just doing his job. And remember, he gets assigned this case. If she had gone to try to find a private defense attorney to do this, they probably would have been like, you should have thought about that before you talked to law enforcement. There's not much I can do to help you take a plea. He does not have a choice. So this is look, the man's trying to do his job. I'm trying, Your Honor. I'm trying. He's doing a better job than Elaine.
2 different locations. No eyewitnesses. Taylor Schabusiness, we learned that she went to school with Shad Therian, middle school, Bayport High School. They were friends. They hung out. You heard from AJ Gannon. He hung out with them as well.
They all hung out.
Can you trust what someone says when they're hopped up on meth, on drugs? The state wants you to look into Taylor Schabusiness's mind.
This is a good argument.
Find out what her intent was.
He has not much else to say.
That's a difficult task.
Y'all, she was on meth. She doesn't
Did
even
she
know
have
what she
a
was
clear
saying.
mind on February 22nd of 2022 as to what was really going on? Accidents can happen. When accidents happen, people can make other choices in a panic. Something for you to think about. This sexual assault charge, how can you have sexual intercourse with the facts that have been laid out and presented to you? It's mind-boggling.
Okay, but
How can you have sex when genitals are in one place and body's in a different place?
Sir.
It's foggy. It's cloudy. It's hard to imagine. Almost impossible to try and figure out what did or didn't happen.
The prosecutor's going to have to reiterate the definition of
and ask that you find her not guilty
sexual assault.
of third-degree sexual assault. You can't rely on everything Taylor Schabusiness says. Think about that, please.
Ladies and gentlemen of the jury, please don't believe what my client said to law enforcement. She was on meth. She was just saying shit. The problem is the shit that she was saying lined up with the physical evidence. So that makes it tough.
She chose not to testify under our Constitution.
There's the constitutional rights. There we go.
She doesn't have to testify.
Constitutional rights. She has rights.
Provides. You don't have to take the witness stand. You have a right to remain silent.
She should have remained silent earlier.
Against her. I would argue that based on all of the evidence and the testimony in this case, that you find my client not guilty of all the charges. Thank you very much for your time.
He's trying. The rebuttal is going to have to redefine sexual assault and say that the facts in this case are clear.
This case is puzzling. This case is bizarre. This case is in absolutely no way unclear.
That's fair.
It is crystal clear what happened to Shad Therian. And we know that. We know that because the defendant told you. She told you what she did to Shad Therian. Is it bizarre? Is it unnatural? Is it strange? Yes, absolutely.
That doesn't mean she didn't know what she was
People do
doing.
bizarre, unnatural, strange things. They engage in criminal conduct. People kill other people and they dismember them. That's what Taylor Schabusiness did. And we know exactly what she did because the words from her mouth told you with specificity what she did. Can we trust always what Taylor Schabusiness says? No, but as Mr. Saunders told you, we trust but we verify. We didn't stop at taking her statement.
I love trust but verify.
She guided the investigation with the specificity of her statement. How can we not trust her statement when she describes in detail the mechanism of injury, which is exactly what is described and confirmed by Dr. Tranquita?
Where to find
excessive strangulation over a period of time with layers of injury, exactly as she described it. Described that his tongue would be out. She described that. Dr. Tranquita described that and showed you that. She described a struggle. He's struggling for his life and she continues to pull that chain, demonstrating her intent to kill Shad Therian. And we know that because we see that in the physical evidence.
I like that they used him as the closer.
We see the marks on Shad's tongue. We see the damage to his neck. She described to you what she did with his body after she killed Shad. And we know that it's true because the body parts were exactly where she told you they were. Detectives are finding everything she says on scene. And you saw it with your own eyes. That just what she told you is exactly where those things were located in that residence. She wasn't cloudy. She wasn't unclear. She wasn't hopped up on drugs. She knew where to find the drugs. She knew where they'd find the pipe. She knew where they'd find the chains. She knew where they'd find the knives. She knew the name of the bag where the body parts were going to be located. She could tell you that she put the organs in plastic bags. She could tell you that she cleaned up with Clorox wipes and she put them in the bags as well. She could tell you that his lower extremities were in the car. This is the most specific confession anyone could ask for, and it is corroborated in detail by the work of the Green Bay Police Department. This is bizarre.
He's not
this
wrong.
This is strange. This is unnatural, but it is in no way unclear. We know exactly what happened.
I like his rebuttal.
We know exactly what Taylor intended to happen for all three of these offenses.
Yeah, you don't need to say much more.
She engaged in intentional conduct in each of these acts. You are asked to look at each of the 6 elements, and there are only the 6 elements that Attorney Saunders described to you. That as to count 1, she did cause Shad's death. There is no doubt she had the mental purpose to do that.
I mean, I don't know how much more you
and
can
that she
get
knew
into
that
it.
her conduct was practically certain to cause it. She described to you how she visualized
You've done
him
what you've needed
struggling,
to do, counsel.
blood coming out of his mouth, but she did not stop.
I get that it's hard not
He's
to take a
turning
victory
purple,
lap, but
she did not stop. He's coughing up blood. He's pissing himself, in her words, but she did not stop. This was a deliberate choice on her part to kill Shad Therian, and she knew that her actions were going to cause that. And in fact, she was asked whether or not she liked it, and she confirmed that she liked it. She was asked whether she was sexually aroused by killing him, and she said she was. Her mental purpose was clear.
he's a
As
little
to
more
mutilating the corpse, again, there's no doubt that she intentionally did
than
that. She
his
described the
co-counsel on
detail.
this.
She described her frustration
So there's
as she's
that.
mutilating this corpse, and she described her purpose in doing so. How else am I going to get the body out of the house? How else am I going to get away with this if I don't cut this body up? And she didn't just cut it up and leave it there. She cut it up, she packaged it, she cleaned up after herself. Her purpose in dismembering Shad was clear. She wanted to attempt to get away with this crime.
She couldn't
A
carry
crime
him
that she
all at once.
intentionally committed, a crime that was not accidental, that was not a surprise to her, that she didn't wake up from this nightmare and then call the police and call Shad's mom. No, she made the second deliberate choice. After deliberately choosing to kill him, she deliberately chooses to dismember him and attempt to cover up her crimes.
And then try to remove him from the
Likewise, the
house.
sexual assault is equally clear. There's no doubt that she had sexual intercourse. And for counsel to say that we can't merely accept the word of the defendant, you're asked routinely in sexual assault cases, juries are asked routinely to take the word of a crime victim with no physical evidence. We don't have to take the word of the crime victim. We have the word of the defendant who confesses to this crime and tells you exactly what she did. Again, with specificity.
Please don't describe
It
it,
tells you, you know what, I did this and I did it with that dildo. And here's where you can find the dildo.
sir.
It's in the wall. It's in the box. I put it away. And what happened? They found it in the box, put away exactly where she described that it would be. And
Okay.
she clearly was sexually aroused by this whole incident, and she described that to you herself. So clearly it follows. It makes sense. It's logical. It is reasonable that she did exactly what she told you she did.
It's not
There's
just reasonable.
absolutely no reasonable hypothesis consistent with her innocence. The only
That's it.
hypothesis, the only
That's
choice
it.
that you have before you here today is to find Taylor Schabusiness
Yep.
guilty
Done.
on each and every count for which she is charged.
Yep.
All of those elements have been proven beyond a reasonable doubt, and I ask that you return a verdict of guilty.
Okay,
Thank
sir. Let them go deliberate. Because if we don't catch up to real time, this jury might be back before we're finished watching closing.
Jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this.
These are the final instructions.
You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 6 forms of verdict will be submitted to you concerning the charges
3
against the
guilt,
defendant.
3 not
Taylor
guilt.
Schabusiness. 1 reading, we the jury find the
These
defendant
are very
Taylor
simple
Schabusiness
forms.
guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant Taylor Schabusiness not guilty of first-degree intentional homicide as charged in count 1 of the
That's it.
information.
This is a
Another
very
reading, we the jury
simple.
find the defendant Taylor Schabusiness guilty
jury
of
form.
mutilating a corpse as charged in count 2 of the information. Another reading, we the jury find the defendant Taylor Schabusiness not guilty of mutilating a corpse as charged in count 2 of the information. Another reading, we the jury find the defendant Taylor Schabusiness guilty of
Let's see
third-degree
what the
sexual
judge says
assault
to the jury
as charged in count 3 of the information.
when he
Another
discharges
reading,
them.
we the jury find the defendant Taylor Schabusiness not guilty of third-degree sexual assault as charged in count 3 of the information. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses
We're
charged.
almost caught up to real time.
You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count.
Yeah, I think they'll be less
This
than
is
an hour
a
as
criminal,
well.
not a civil case.
I'll be
Therefore,
surprised if
before
they're
the
not.
jury may return a verdict which may legally be received,
You
the
have to be
verdict must be
unanimous.
reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote
I will
is
put up
entitled
a
to
poll
no greater weight than the
after
vote
the
of
jury's
any other
discharged
juror.
and the court
If
confers
you
with
need
the
to
lawyers.
communicate
Then I'll
with the
put up a
court
poll.
while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have a question, the court will talk with the attorneys before answering it, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions.
I don't know
in
if they're going to
writing
have any
or
questions.
orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in
Yep.
open court.
And that's
The
it.
court may ask each of you if you agree with this verdict.
I like the way that
Now, ladies and
these
gentlemen,
jury
this is
instructions
the
line
unfortunate time, because now is the time
out
when we
the,
select the alternate jurors.
line
I'll tell you
out
what
the
process is gonna
instructions.
be. The computer has selected 4 of you. We're going to read those names here shortly. If your name is read, I'm going to ask that you simply stand up and go have a seat in that first pew right there, because I'm going to want to address you, first pew right here, because it's open. And I'm going to address you after the other jurors have been excused. The remaining 12 jurors are going to participate in the deliberation process, and you will accompany the bailiffs to the jury room. If you're selected as an alternate, your participation in the case at this point will be concluded. I will make sure, however, that you are addressed by a bailiff who will assist you in retrieving any items that you may have in the jury room. So at this time then, I'm going to ask that the clerk read the names of the 4 jurors that have been selected by the computer randomly.
Nicholas Rose.
All right, they are doing the alternate jurors. As they are doing the alternate jurors, the court probably should have muted that, but the chat said that it wasn't muted. Oh, they shouldn't. All right, hold on. We're just gonna let those jurors be dismissed. They definitely didn't put it to the seal nearly fast enough, but they are gonna say the juror's name. Sorry, they should have done it by number. They didn't, but it looks like those jurors are all dismissed. So those jurors are dismissed and are no longer jurors, which means they're free to talk about the case. But my husband was, I saw that they showed them too. So they should have read it by number. I agree. But thank you, chat, for giving me the heads up. This has already been a problem in this case. We'll talk about that.
All rise for the jury.
We'll talk about that later. They're rising for the jury. The jury's going out to deliberate now. Well, the jury went out. We're behind a little bit real time. So the jury went out to deliberate maybe 3 minutes ago. Let's see how much time the court's going to give them today. Thank you, chat, for keeping me apprised since we were a little bit behind on that. The judge isn't going to be thrilled with that. So they should have done the alternates by number.
I want to first address Mr. Rosick, Mr. Lynette, Mr. Beerhalls, and Ms. Schrader. I want to thank you very much for your service on this case.
Good Lord, Your Honor. Okay. I didn't know he was going to do it too. Sorry, chat. We'll do our best.
All paid careful attention. I've been able to observe all of you throughout the trial, and I really appreciate that, and so do all the parties. At this time, your service in this case is completed. Many jurors ask if they're allowed to discuss the case with others at the conclusion of their service. Because your role in this case is over, you are not prohibited from discussing the case with anyone.
They are allowed
However,
to talk to anybody.
You should know that you do not have to discuss the case with anyone or answer any questions about it from anyone other than from the court. This includes the parties, the lawyers, the media, or anyone else. If you do decide to discuss this case with anyone, I would suggest that you treat any discussion with a degree of solemnity such that whatever you do say, you would be willing to say in the presence of your fellow jurors or under oath here in open court in the presence of the parties. Finally, should any of you have any questions before you leave today, please let the bailiff know before you leave. And I'm going
to poll how long this jury will take.
Before answering any questions asked by anyone if you choose. The bailiff is standing right back there. I'm just going to ask you to get up then and accompany her out that door. And if there's anything that you need to retrieve, but again, thank you for your service.
All right. The judge is going to talk to the attorneys, I would imagine, and then we'll go from there. It seems to me that the normal practice in this courtroom is to call the jurors by their names. I always practice in jurisdictions where the jurors were called by number. So I think that the judge was in his mode. But we're gonna put out a quick poll on jury time. Just give me a minute. Let's see what happens. But this is the normal practice of the courtroom, and wasn't even really thinking about it. But jurors are allowed to disclose themselves, and I don't think their identities are sealed, so those identities can be, at least for the alternates, can be disclosed.
Before we recess, Mr. Saunders?
No.
Mr. Freilich?
Not at this time.
Very good. Then we are in recess. I'd ask the parties to remain very
Close
close here to the courtroom for at least 30 minutes. Oftentimes, if questions come in, they come in early. After that, if you just simply leave a cell phone number where we can reach you, then you're free to depart. But I'd still ask you to remain close to the courthouse. But at this time, then, we are in recess.
Thank you.
I would ask the attorneys to remain very close. Yes, because I would ask you to remain very close for the first 30 minutes. I think the judge thinks that this could come back within 30 minutes. I mean, I've had verdicts come back in 10. Even though a case is serious, and even though charges are really the worst charges you can see, you can get a case where jurors come back very quickly. So now we're getting caught up to real time on the feed. I'm going to go put up a poll. I'm going to get to questions, and we're going to keep an eye on the feed. So when will the jury decide? Under 30 minutes, 30 to an hour, a few hours. I'm trying not to type wrong. Tomorrow. All right. We're polling the community. Let me see what's going on with this feed real quick. Let me refresh this. Now that we're all caught up and on verdict watch. So that's where we're at. Should we do our bumper? We have a verdict watch bumper. We could do a verdict watch bumper and then go to questions. It's officially verdict watch, and per Law and Crime, they say verdict watch officially began at 4:52 p.m. Central Time. So we will just keep an eye on that feed, and maybe another, Miguelina, if you see any other feeds. But if we hear anything, we'll see. Let me just put up. I don't know if anybody's following this case really closely anywhere other than the streams. So we will see what happens with all of this. So I don't know if there's anyone else. Let's see. If Chanley Painter is, I don't know, because normally we will see those that are covering it will indicate when the judge says that something is happening. So we'll just keep it on that. But we have verdict watch going on. We have lots of questions. So I'm going to get to your questions, and that's what we're going to do. So thank you, Miguelina, for keeping an eye on alternate feeds while I keep an eye on this one. And let's get to your questions. You guys have a lot of really good questions. I can't imagine this is going to take all that long. I will be more and more surprised the longer that it goes. So let's just answer questions and see. So this is in Central Time. The jurors also, remember, let's keep this in mind. The jurors have not gotten to talk to each other about this case. They are going to select a four-person, and they're going to want to chitty chat, especially if they think, or if they know that they are going to vote guilty. They might want to have a minute to converse, because if she is found guilty, they have to go back on to jury duty for this case tomorrow. How long they've been deliberating already. They started deliberating at 4:52 p.m. Central. It is right now 5:02 p.m. Central, so 10 minutes. They've been deliberating for 10 minutes. All right, so they're going to need a chance to chat. Chris T asked, is this a death penalty case? No, this is not. This is, we're going to talk, let's talk about that. Let's get to questions, and let's talk about this case real quick and what's happening next on this case. So this is not a death penalty case. She is facing life without the possibility of parole. However, she has also pled a death penalty case. Sorry, that's me. She has also pled not guilty by reason of mental disease or defect, NGI. So the jury is also going to have to decide, if they convict her, whether or not she is responsible for this crime, and whether or not she had the capacity to know that what she was doing was wrong. I cover that in this week's podcast that went out today. So that is today's episode of the Emily Show, breaking it down. So if she is convicted, the jury will then deliberate the penalty, which will be either she was NGI or she was just guilty and just go to prison. So that's what they will have to decide later. I said that's strange. That's what they will have to decide later, whether she is not guilty by reason of insanity or not guilty by reason of mental disease or defects. So the NGI might take longer. For those of you in the chat saying NGI could take longer, the NGI could take longer, and that will be a separate trial. So that is a part of the trial that comes next with experts. And I will be covering that when we start tomorrow. So, all right. Or if it starts tomorrow, maybe not. Emily won't finish questions before they come back. Maybe not. Is there an estimate for how long the second portion of the trial will last? They are giving it 2 days. So, question, what happened between her and her first lawyer? She lunged at her first lawyer in court. I don't know what happened with the relationship between her and her first lawyer that went sour, or if she was just pissed off, or if she was doing it to try to delay her case, because that can happen too. I don't know, but she attacked her attorney in court, and that attorney was removed. All right. So as we get to questions, I will let you know, if you are not signed up on our Law Nerd Alert, it is our email system, so that if I decide to stream earlier tomorrow, depending on what happens today, we can keep you in the loop. So lawnerdalert.com, you can go and sign up if you are newer here and you have not done that yet. I send you emails especially when I'm going to be going live outside of when I normally go live. So today was kind of a surprise, like, oh, hey, I'm home. It's going to closing. Here we go, live. And so we will send out those alerts in case you don't get the alert on YouTube or elsewhere. So that is a free email list. And of course, we don't share your data or information with anyone. Let's continue on with questions. All right. Question, has the second part of the case been scheduled? And if she is convicted today, the second part of the case will start tomorrow. So has it been scheduled? Yes. This whole part will happen it's supposed to happen before the end of the week. The judge gave them a week-long estimate. It's Wednesday. So it will start once they come back with a verdict. The next phase of the trial will start. If they come back with a guilty verdict. If they acquit her, which seems unlikely, if they acquit her for some reason, which would surprise me very much, then there will be nothing else. But if they convict her, that will start tomorrow. Is this jury sequestered? No, they are not. No, they are not. So let's see. Do you think she might have an outburst in court during the verdict? I don't think that would be a good idea, because she has the next part of her trial to go, but you never know what people will do. I have seen defendants who have been very well-mannered during trial have substantial outbursts during verdict. So it's not unusual, and the courtroom is normally prepared for that. So that can happen. All right. Victor said, say hi to my SIL Kim joining us on this live. Hello to Victor's sister-in-law, Kim. Thank you for joining us on this live. Cheryl asked a question earlier on. Emily, did you see that YouTube was brought into this trial because a juror was told they were videoed and it was put on YouTube? The judge handled it well. I thought I did see that as I was driving today. I was very surprised by that because, well, I guess I need to rephrase now that they've called the jurors by name, and some of them seem to have possibly been on video as they were exiting the courtroom, even though they were excused from service and were no longer jurors. I don't know what happened there. It seemed that the court thought it was surprising that might happen, and I don't know. I'm gonna Nightbot, stop trying to gain attention. That was my fault. I think that, or I was surprised that, I guess, as I'm trying to rehash my thoughts, I was surprised that came up. A juror was texted that they were seen on TV, which was surprising. A coworker had texted them. I don't know if there is anyone outside the courthouse that could be filming. I don't know if that's a circumstance, but the judge did not think they were filmed in court. Laura said she is wearing a shock belt. They were adjusting it this morning. I would not be surprised if she were. Some jurisdictions use them, some jurisdictions do not. But there are shock belts that can be used in court that goes around the torso of a defendant, and they can be stunned if they lunge at an attorney or something. That is a very severe consequence, and it normally happens only if a defendant is lunging for their attorney. And when a defendant has attacked their attorney in court before, it's not surprising that is something that she would be wearing at all. So what else? Let's get to the rest of questions. Emily, have you seen Stars on Mars? I mean, not a question about the trial, but I'm here for it. Have you seen Stars on Mars? I have seen some of Stars on Mars. I haven't caught back up, but yes, I saw that that Tom was on it. So I think the judge handled it well. We will see what happens. Did you see her point gun fingers at a witness? I did not. I would need to go back and review because, again, during the Murdaugh case, they were talking about whether or not Buster was flipping somebody off, and it looked like he legitimately might have been scratching, but then when you freeze frame it, it might look like he's flipping somebody off. I would need a lot more context for it. But no, I did not see that. And we answered that earlier. A lot of questions about whether this is a death penalty case. This case will, if she is convicted, will come down to life in prison or life in generally a locked mental health treatment facility. I don't know if that's something that you would want. It just, that can vary state by state as to what the better option is. Adina, what's on our calendar? I don't know. I would need to go look. Some things have been put over. There's a preliminary hearing coming up, but things that are streamed, I would have to go look at my calendar. I don't know off the top of my head. Matt Bound, good to see you. Hello, Spiffy Legal Mumbo Jumbo Talkie Friend. Floofy says meow to the boys. The boys are lounging. What does it mean by kill another? I think this is talking about jury instructions, and I would need to look at the languaging of the instruction, but the killing another language in the homicide statute attributes for one person killing another person. That is part of what that is. Do jurors get to review the evidence amongst themselves as they deliberate? If they want to, they absolutely can. They get to choose what they review, and they get to choose what they review. So that. Let me go take a look. I saw a couple of you asking about or saying that Kathy had posted what happened in court. So let me go take a look at that as we are talking through this and see if there is a clip of that. Or Miguelina, you can look. It looks like let me go see if I can find it. Which I don't see off the top of my head. So, all right. I'm going to just let that ride. If we see it, I will pull it up and take a look. But I'm going to try to get through all the questions we have before we go before I go looking at other stuff. Alice in the chat asked, do you think the lawyer did a good job with what they had? From everything I have seen, this lawyer the defense attorney worked very hard with what they were given. He made legal motions that some might have not made. He really fought to get some of the charges thrown out. Technically, under the law, I think he did a very good job with what he was working with, which was not a lot. Which was really not a lot. Oh, thank you, Migley. That's good. That's fine. Thank you. I will take here. Let's pull this up and we'll take a look. This was posted by Law and Crime. Let's go just take a look. Since the question had been asked and now we're talking about it, let's go take a look at it before we finish Q&A, and I'll tell you what I think. So, if it really is a huge problem, would the court have addressed it? Maybe, but we'll see. Let's see. The jury has now been out for 20 minutes? All right. As the countdown goes on, let's take a look at this. Thank you to our moderators and to our and to Megalina, my producer, for bringing this up. We'll see what timestamp this is and maybe go back and look at it at another point. I don't know if it'll matter. All right. Let's take a look. This is a short posted earlier today. I don't know if there's audio or not.
I've got some concerns. Clear, and I'm going to afford the attorneys an opportunity to talk now that I've clarified.
I don't know.
Because I've got some concerns.
I'm going to do it without audio because they clearly slow it down to show it. I mean, you guys can tell me what you think. It is not the... Look, when playing it, this is a much more deliberate motion than what we saw from like a Buster Murdaugh. And again, sometimes things get blown out of proportion during trials, so I'm always very cautious. But that is pretty specific. This is more than the internet reading into like Amber Heard blowing her nose or Buster Murdaugh like doing whatever. This is more specific than that for me. So I don't know who this was toward. I'll go find the thing later. I don't know if she's looking at a witness or the judge, but I'm just going to let it roll a few more times. Yeah. So I don't know if anybody perceived it. I don't know if the prosecution perceived it. If anybody perceived it, it doesn't seem that it got addressed in court or we would have heard about it. But look, man, I saw some in the chat saying, could it be a peace sign? There is a thumb up. It is not a deuces. So that does not look, that looks deliberate to me. However, what I will say, if you listened to today's podcast, there was conversation when the judge was determining competency about her evaluation from the doctor that said that they could not rule out that a lot of her behavior in court was deliberate. So is this deliberate behavior? It looks like it's deliberate behavior, but we'll see. We'll see we'll see. I don't know if it was brought up in court at all, but I can see how that can be interpreted that way. I don't think that one's a stretch. Sometimes I look at stuff and I'm like, whoo, that's a reach. I don't think that's a reach. I understand why that's being interpreted that way. Andrea said, I'm still confused why she killed him. Yep. Don't know. No idea. No idea why. Yep. No idea. However, that's not uncommon in murder cases. Sometimes people kill other people. She was also using meth. People do really, really awful shit under the influence of meth. Question, if she is found innocent, it's not innocent. I'm not being picky. Maybe I am being picky. It's not guilty by reason of mental disease or defect, meaning she cannot be held responsible in the same way. Will she go into a psych hospital? Yes. What the facilities are like in Wisconsin, I don't know. So it's not that she's found innocent. It's saying she did this. However, under the law, we are not going to punish her the same way because she could not perceive that she did this. I don't think that I want to hear the evidence, but based on everything I've seen in this case, I think that's going to be a difficult lift for the defense. I think what the defense has, going for them is the gruesomeness of the crime. People do gruesome, appalling, horrific things that are well outside the bounds of what is acceptable behavior in our society. But that does not mean that they don't perceive the right and wrong. There are people who just don't give a fuck. And if that is the case, the behavior alone is not enough to be like, this is clearly behavior where she can't perceive right from wrong. She might just have wanted to do the things. And it seemed like she had a very thought out reason for dismembering and decapitating, which is she couldn't carry all of him up the stairs to get him out of the house from the basement. So she figured if he was maybe in not one contiguous piece, it would be easier for her to get him out of the basement and hide her crime. That is a thought through process. That is not a I can't perceive what I've done wrong process. So, is it most likely that she'll be found guilty? I think so. That's what I think. I think so. Most cases, I'm like, we'll see what a jury does. My bigger question in this case is how long will the jury take? Do we know if she's on court-ordered medication? No idea. It's possible. Emily, are jury instructions the most common cause of appeals? I don't know if it's the most common cause of an appeal, like a conviction, I guess, is the most common cause of an appeal. But when things are overturned or when things are remanded to fix or for a new trial, jury instructions are one of the most common areas that things get messed up. Like messing up jury instructions is a huge problem. It's rare, but it's a huge problem. Cheryl said, are jurors discouraged from showing emotions during trial? It depends on the judge, the jurisdiction, and what the jurors are doing. But no, jurors show all kinds of emotion during trial. If a juror doesn't like an attorney, you can tell. There are times that jurors are just like, I don't want to hear shit you have to say. And you can see it on their face. You can see it on their face. So, no, normally not discouraged. On factual, Terry, this is in the podcast today. The head in the bucket was located by the victim's mother. It's horrifying. Horrifying to me. Absolutely horrifying to me. So it just depends. If a juror is being very bold in their reactions, I mean, they're the jury. The reason that courtroom participants are admonished, so those sitting in the audience are regularly admonished about reacting neutrally. But the reason that's done is so their reactions don't influence the jurors. The jurors are there to influence each other. That's what they do in deliberation. That's what they're doing now. They're having a conversation. They are influencing one another. So the audience is admonished. The jurors generally aren't. And I've seen jurors take things very seriously, but I've seen eye rolls and head shakes. I've seen hands crossed and what have you. Absolutely. Nishay in the chat asked, did the victim's mother testify? Yes. At the very, very beginning of the trial. Yes. So, yes. So his mother, yes. His mother, and I covered this a bit in the podcast, but his mother heard the screen door or the storm door on the house slam shut. Those of you that have loud and heavy storm doors know exactly how loud that can be. Heard the storm door slam shut, saw the light still on in the basement. And if she hadn't, this case might not have come down the way that it did, but saw the light on in the basement after they heard the storm door slam. So within minutes of that door slamming, which is when the defendant left the home, saw the light on and went down to see what was going on in the basement, and then discovered the head in the bucket. And then law enforcement, 911 was called very, very shortly in time thereafter, because the mother went and woke up her boyfriend, who also, I believe, testified on Monday. And then he called 911. They played the 911 call, and you can tell that they have just woken up and they are in shock and discombobulated and are just like, I don't even fucking know. Like, I don't even fucking know what this is. Law enforcement got to their house, figured out that the last person with the victim was Taylor Schabusiness, and then got to her house within like 20 minutes. And she still has blood on her hands and her clothes. So they showed up to her house not long after she got back to her house in the minivan. So law enforcement was like, we are going to need backup. And then they figured out it was her, and then went to her house. This all happened very, very quickly that early morning hours, after 3 a.m., those early morning hours, and got to her house very quickly. Just very quickly. Heartscapes Reiki surprise live stream on my birthday. Happy birthday. I'll receive this as a birthday gift. I hope that it feels like a gift. This trial is a lot. Is closing arguments when murder trials are won and lost? It depends on the facts of the case. In this case, no. No, this case is won and lost in the defendant's statement to law enforcement. In some cases, in more complex cases, yes. Divine Inhale asked a fantastic question that I think I addressed in the podcast some, but I wanted to talk about it more. But don't you have to be mentally ill to do this? There is a difference between a choice that people might not make and the wildness of this case and the grasp of common behavior that is lost when you snap and murder someone. Because there are some murder cases where you look at the case and you're like, I mean, I wouldn't kill someone, but I understand where you're coming from. Like, heat of the passion murders, when you see people murdering their abusers, things like this, you can look at it and be like, I mean, not the action I would take, but my rational brain understands. Like, I get it. And then there's cases like this where you're just like, what the ever-loving fuck is happening? Methamphetamine is part of that. But the other part of that is people operate in different ways, choose to do things in different ways, and you don't have to be not competent for trial or NGI to do this. Do you have to not be dealing with reality the same way the rest of us do? I think so. However, that doesn't mean that she will automatically be NGI. And that's why I think this case is really interesting, is because the behavior is so far outside the boundaries of what is acceptable in society that you look at it and go, but this behavior is horrific. How do you do this to another human? But that doesn't mean she didn't know it was right. It doesn't mean she doesn't know what she was doing. It doesn't mean that this was caused by mental disease or defect. It doesn't mean that she thought she was doing something else. She knew what she was doing. So she knew the action she was taking. She was trying to cover it up. She knew that murder was wrong, or she knew the difference between right and wrong. So when you're dealing with an NGI case, the behavior does not make the NGI case. The underlying diagnoses of a defendant is what makes that case, and we will see experts talking about this case. So, are there those in society that behave this way? Yes. Do we see serial killers do things that are well outside the boundaries of what people do? Yes, but that's not just true in murder cases. That's true in your CP cases and other cases like that. Most of our crimes, especially these horrific ones, you look at and go, what? Some of the crimes you're like, yeah, okay, why is weed still illegal? So there are things that we understand, and then there are things that we're just like, we're not going to do all of that. This is one of those cases where it's hard to look at the behavior that happened and then go, but how do you not go NGI? And it's because that law is very specific. I saw a lot of questions about this, and I don't know if I have any of them pulled up. This Aunt Clara asked the question: is drug-induced mental illness sentenced or judged the same as typical mental illness? And I think this area of law gets complex. I am not an expert in psychiatry, so the diagnosing of things is not me. However, when you get to whether or not voluntary intoxication is an excuse or drug-induced mental illness, they are two different things. So when you can have organic brain damage or defect from extended drug use that can count as the underlying mental disease or defect legally for NGI. So someone who has used a substance for a period of time that has caused actual organic changes to the brain, that can be there, but not the fact that they are using at that time and at that time they were under the influence and that caused the thing. So they're it's actually a really complex area of law when you talk about drug use that has led to actual changing of the brain. And then if that is voluntary intoxication or not voluntary intoxication, most of the case law comes down with voluntary intoxication means you're intoxicated at the moment, not that you've caused this damage and you're not under the influence at the time, but that the underlying has happened. So I think that's probably what they're going to argue here, but we'll see. There are mental diagnoses here that we will see. And then we will see how the court navigates that if she is convicted. So our Hampy said in the chat, are you going to do verdict watch? We're in it right now. We're in it. The jury has been out for 37 minutes. Let's see. Our poll had 26% at under 30 minutes. Let's end our poll and we'll put up a new poll. When we get there, we're going to go ahead and end this one. So let's see. Let's keep going. Just sending a bit of love from South Africa. Thanks for making law interesting. Just Gray, you're welcome. Thank you so much for the super chat. Thank you, EDB. I survived the hospital stay with hubby. He's home resting. I'm so glad he's home resting. Thank you for the support. It made a huge difference. And I don't know if there's anything we can do except be here and show up. I'm glad that your hubby is home resting. Do you think the judge is grossed out? Probably not. Like, judges see a lot of shit, and as do the attorneys, and has been dealing with this case for quite a long time. So the first time it might be like but if the judge, particularly if the judge had been a criminal attorney before this, I mean, I don't know if you ever get used to it. Some of it you get used to, and you're just like, okay then. And it also depends on what the judge has seen in their own work and in their own courtroom. There are definitely things that gross me out way more than this case. Question, did she testify? She did not testify. She did not. I think the judge is annoyed by her laughing and smiling. This may be particularly true if the judge thinks that is forced. So there is a lot of desensitizing that goes on. There is a lot of compartmentalizing that goes on. And there is a lot of just, again, Photos are not nearly as bad as having to deal with it in person, and you're just at some point it just is. This case is harder to talk about because it is so graphic, but the facts of this case, they are disturbing. But they are not the type of case that I can't go through and just be like, oh, okay, this is what happens. This one does not bother me nearly as much as other cases that I've chosen not to cover on the channel, which is why we did closing arguments today. So let's see. I've been watching the whole trial. The only time Judge W was disconcerted was the pics of the body pieces that weren't made public. And those can be a little gnarly. Yeah, those can be a little much. Do all jurisdictions do the second part of the trial with their defense? I don't know if I can't tell you if every jurisdiction bifurcates it. All the jurisdictions I've seen have bifurcated it, but some jurisdictions will also allow you to plea before you can admit that you did it and then still go to NGI. Sometimes you don't, especially when her competency was in question. I think there was never going to be a plea here. Her defense argued competency so much in this case, but it just depends on jurisdiction. I don't know. I can't tell you if every single one does it. Most of the ones that I have seen do it that way. What happens in the second phase? They will bring in expert testimony to discuss whether she could perceive the rightness or wrongness of her actions, whether she has an underlying mental disease or defect that made it so that she committed the act, but she didn't know that it was wrong. So chat is saying there's a verdict. Tell me where you're seeing it. I don't doubt it. I see verdict watch still up on my screen at 41 minutes. I'm not surprised by that. Just let me know where you're seeing it. I'm seeing it. There's a verdict. There's a verdict. There's a verdict. I'm not done with super chats. I'm not done. I'm not done. Oh, yep. They're all back in court. Let's pull this up on stream. We don't have any audio out of court yet. We'll have audio soon. It looks like we have a verdict in just about, they're typing it on the screen as we talked. It looks like there's a verdict just in 42 minutes, which her attorney has to be leaning over and telling her, this is my speculation. This is her attorney leaning over and telling her that there is that this is going to be a guilty verdict. Is drug-induced mental illness sentenced as the same? Okay, we got to that one earlier. I don't even know if we have time to send out a text to the text group. Let me see if we can. So send the jury back. She's not done. They've got to review the jury verdict forms, and there can be issues on the verdict forms or things that aren't filled out, especially when they go quickly. But 42 minutes doesn't surprise me. It gives the jury time to chat a little bit. Let's see if we can send this out to our text crew real quick. Just give me a second. Let them know that we are doing this together. But this is going to be, who won the poll? I know everybody that said 30 minutes to an hour won the poll. So I think the reality starts to set in here, and that's you will see more bailiffs start to come into this courtroom because they know that this is a guilty verdict with this speed. So it'd be really surprising if it's not. And everybody kind of knew that was the result of the thing. All right. The judge told the attorneys to stay close, especially within the first 30 minutes. In 42 minutes, this verdict came in. So congratulations to everyone who put 30 to an hour. You win. Okay, I mean, this is why we keep streaming. Join me live now. All right. Let's send that out to our text crew. All right, email crew. I think you're already here, but Warren, if you will send it, we have a verdict. That would be great. All the lawyers are there. Oh, there's going to be a lot of law enforcement in here. It looks like the judge is coming back onto the bench. The judge is going to tell the lawyers that there's a verdict and then bring the jury. We'll get to bring the jury soundbite at some point. Emily, quick question. Will the judge give his thoughts on what she's done after verdict? Not until sentencing. Who called the police at the scene? The victim's mother's boyfriend. Steph K, this is this is a good question. Yes, the law in Wisconsin, and different states have different laws. Some states separate these things, some states don't. The state in Wisconsin says that the victim, it is the same if the victim is alive and or dead. So yes, it still is. But the defense did argue that under the law in Wisconsin, that this is not the appropriate statute for it. Was she competent to confess? Paul, the defense argued this as well, that with her using drugs that evening, that she was not maybe competent to confess, but they have done multiple competency evaluations in this case and determined that could come in. But the defense fought really hard on that. Look, with a difficult case, her defense attorneys have worked for her. They have worked hard and continued to work hard. So Dr. Kit McGuire said, I passed my defense. Officially, Dr. Kit, thanks to EDB and the best chat on the internet for being study buddies. Kit, you're welcome. We're here to be all of your study buddies. And get it. Congratulations, congratulations, congratulations. Just say she's convicted today. What's the benefit of her being found guilty due to mental health? If she is found NGI when this jury comes back tomorrow to determine that, I'm assuming, of course, that she's convicted with a sentence this quick. That's what's going to happen. But if she is determined to be NGI, there's the possibility that she could get out. So there's the possibility that after treatment, she can get out. Otherwise, it's life without parole. So it gives her the chance to get treatment and to get out. So that's why. Can insanity stand when it's due to self-ingestion of drugs? Voluntary intoxication negates it. So it depends. If the prosecution's going to argue that her hands are unshackled at the time, which is also probably why she's in a shock belt.
Before we bring the jury in, Mr. Saunders?
No.
Mr. Fraley?
No.
Very good. Then we'll bring the jury.
Bring the jury. And we bring the jury. And there is the verdict. There we go. For those of you just joining us, let's go ahead and swoop. If you're just joining us, the Schabusiness murder trial started on Monday. It is Wednesday afternoon. This jury was out for about 40 minutes when they came in with a verdict. If she is convicted, this jury will have to come back tomorrow to start the second part of this trial. So that's what's happening now. The jury is coming in to render their verdicts. You will hear verdicts on 3 different counts. Count 1 being the first-degree intentional homicide, count 2 being the dismembering of a corpse, and count 3 being the sexual assault. So there will be 3. This is one of the faster decisions. I don't think there was any hesitancy on the part of the jury. I think they wanted to talk.
And my understanding is that the jury has reached a verdict. Is that correct? Right. If you would hand that to the bailiff then, please.
So what is the seal behind the judge? That seal should be the seal of the great state of Wisconsin. So the jury is back. Yes, the jury is back. I miss the Murdaugh judge. I miss the Murdaugh judge too. I liked him. I like this jury. So this jury is going to check the verdict forms to make sure they're in order.
First verdict
and is going to read them now.
Follows. We, the jury, find the defendant, Taylor Denise Schabusiness, guilty of first-degree intentional homicide as charged in count 1 of the information.
No surprises.
Dated this date, July 26th, 2023, signed by the foreperson. Second verdict reads as follows. We, the jury, find the defendant, Taylor Denise Schabusiness, guilty of mutilating a corpse as charged in count 2 of the information. Dated this date, July 26th, 2023, signed by the foreperson. The next verdict reads, we, the jury, find the defendant, Taylor Denise Schabusiness, guilty of third-degree sexual assault as charged in count 3 of
guilty
the
on all counts.
Dated this date, 26th day of July, 2023, signed by the foreperson. The verdicts appear to be in order.
Sorry, y'all.
Either the parties request that I poll the jury.
Probably.
Mr. Saunders?
No.
Mr. Fraley?
Yes.
Okay. Ladies and gentlemen, I'm going to do what's called polling.
They're going to ask each juror
process. All I'm going to do is go
if
down
this is
the
their
line
verdict
and ask each of you if this is your verdict. Your answer is either yes or no. I'm going to start in the back corner, ma'am. Are these your verdicts?
Yes.
Ma'am, 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 are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts?
Yes.
In the front to the right, ma'am, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts? Okay, the jury has now been polled. Ladies and gentlemen of the jury, for
We'll see you in the morning.
today, your tasks are concluded. We're going to start tomorrow morning on the second phase, at which point in the beginning I will give you some further instructions, and then we will get underway on that phase. The attorneys and I have a few things that we're going to need to take up before that phase starts, so I'm going to ask that you be in the jury room by 9:15. I want to start right at 9:15, and we will hopefully get our matters resolved ahead of that time.
Can we talk about them now? I want to know.
But for today, your service is concluded. I am going to, again, read you that instruction that I've done every day since you've started. Please do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury.
They are not done
do not
yet.
Use a computer, cell phone, or other electronic device with communication capabilities to share any information about this case. For example, do not communicate by blog, email, text message, Twitter, or in any other way
I
on
think
or
we
off
have to
the
call it
computer.
X now, Your
Do
Honor.
not permit anyone to communicate with you, and if anyone does so despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based upon the evidence presented
They
in the
still
courtroom.
can't talk about
People
it.
not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case.
I'm grabbing your
After
questions.
this trial is completed, you are free to communicate with anyone in any manner. We are done for today. Have a good evening. We will see you tomorrow morning at 8:15 or 9:15 sharp. All rise for the jury.
Oh, does he want the lawyers at 8:15 tomorrow? Oh. We're going to talk about what happens next once the court is done. Court is not done for the day. The jurors are leaving. They will be back tomorrow for the second phase of this trial, or the second trial. Now that she's been convicted, we're going to hear more about the scheduling of that now.
Regarding Dr. O'Donnell is still a contested issue. I'm seeing nods from the state.
As of last night, yes.
So here's how we're going to handle it.
God, this judge is hard to hear.
Indicated to the jury
He doesn't talk into the mic.
that court at 9:15. Mr. Freilich, it's entirely up to you if you want to bring Dr. O'Donnell here tomorrow morning at 8:15 for me to hear from. But I'm going to indicate to you the parameters of where that situation is.
Tell me.
I've reviewed your memorandum, which is all I can really work with, because this is what you've essentially said to me. This is what he's going to testify about. The first opinion is that Ms. Schabusiness was acutely intoxicated.
I am going to pause so that I can explain real quick what they're talking about. So, Taylor Schabusiness was convicted of all three of the alleged or the charged crimes, not alleged. So, after the conviction, she has been found guilty. She has pled NGI, meaning that she has said that she is not guilty by reason of mental disease or defect, that there is something that has caused her to legally be not responsible for the things she did. I did it, but I'm not responsible for doing it. The attorneys are still fighting over the doctors that are allowed to come in. So they are right now talking about what's going on with the doctors that will testify tomorrow. So 12 jurors convicted Taylor Schabusiness of first-degree murder, and the other charges against her. Her lawyer now wants an NGI verdict. 5/6 of the attorney or the jurors have to agree on that verdict. They come back tomorrow to hear evidence from both sides regarding the NGI, and the case kind of switches because the burden then is on the defense. So they are talking about the defendant's motion with regard to this, and they are now getting into the testimony, and that's what the judge is going through. So this is going to line out what the contested testimony is, which is why it's important to go through. And then I will answer all of your questions about what that means between NGI and the rest of it. So I see your questions as they're coming in. We'll get there. We'll talk about the alternates. So let's continue on. So she will not be sentenced tomorrow. They will be going to the NGI phase tomorrow. Let's listen to what the judge has to say. And then I am grabbing questions and I will get to, hopefully all of your questions as I can. We're here.
Intoxicated and impaired by acute methamphetamine use at the time of the alleged asphyxiation. The problem I'm having with that.
Let me back up real quick because, again, voluntary intoxication is not going to get you to an NGI verdict. If she was acutely intoxicated, then she is just guilty.
Tomorrow morning at 8:15 for me to hear from, but I'm gonna indicate to you the parameters of where that situation is. I've reviewed your memorandum, which is all I can really work with because this is what you've essentially said to me. This is what he's going to testify about. The first opinion is that Ms. Schabusiness was acutely intoxicated and impaired by acute methamphetamine use at the time of the alleged asphyxiation.
Acute means at the time.
The problem I'm having with that assertion is I'm not sure it's relevant given
Correct.
The status of the intoxication defense. So I'm not sure that having it here is going to assist you in that, but and I need you to understand where I am regarding that topic before you decide that's what you want to bring it here for. The next point is that the long-term and excessive use of methamphetamine has chronic brain damage consequences.
This is getting to the difference between that we talked about a bit earlier, the difference between acute impairment or being under the influence and habitual drug use leading to actual organic brain damage, like damage to the structure of your brain, which can happen. It's fucking terrifying. But could the pattern of drug use have fundamentally changed her brain to the point that it is now categorized under NGI? The problem is she was acutely intoxicated at the time, and that's going to make it very difficult. So the second opinion is that the use of methamphetamine has caused chronic brain damage to Taylor Schabusiness.
The problem with that situation is I don't know that he is competent to diagnose chronic brain damage. So while he could assert that long-term excessive use of methamphetamine has chronic brain damage,
it can happen. He's saying, I'm sorry that I keep pausing. The judge is saying that this expert might not be competent to testify to that as to this defendant versus to that generally.
Consequences. I don't think he's going to be qualified to testify that
as to this
professional,
defendant.
I can say to a reasonable degree of certainty used in my profession that Ms. Schabusiness has chronic brain damage. Frankly, I think the only opinion that's been asserted regarding her mental health condition as far as a diagnosis is bipolar, and that was done at Nicolay, and there's some dispute about whether that was an accurate diagnosis, but I don't know that one would qualify bipolar as being a chronic brain damage. So I'm concerned that if he's going to come in and start opining about that the connection won't be made. And then, of course, even if he is able to say that she does have chronic brain damage, the next step he has to take is that somehow that impacted responsibility. And I think there's a concern there as well. But I'm putting you on notice.
They're talking about the expert that the defense wants to bring in.
Of that view that I'm starting to develop regarding the submissions you've made to me. The second bullet point is that long-term adolescent use of marijuana arrests brain development. Again, I'm not familiar with the diagnosis that any qualified psychologist or other professional qualified to make such a diagnosis has.
You can't bring in an expert to make blanket statements that she used and smoked a lot of weed as a child and that stunted her brain development. Therefore, that's not going to work. Okay.
actually made in this case. I don't know that one equates brain development with bipolar. I've never heard that, but I'm not an expert. So the notion that you can opine that
Chad, I'm with you. Leave the weed out of it.
As an adolescent might have brain damage, I'm not sure is going to be useful to this jury. Because
I don't even know. I have seen all the case law, and the case law often relies on scientific studies with regard to methamphetamine use, particularly, and organic brain damage and long-term use of methamphetamine, and then it actually causing brain damage. I've seen nothing like that with weed. Again, I don't know everything, but I have not seen, by far, I have not seen case law addressing marijuana stunted brain development, and stunted brain development, which is what this judge is talking about, therefore being an underlying mental disease or defect. Remember, in law, you have to follow the chain of case law. Has this thing in the case law met this definition of mental disease or defect? And I don't think that's what's going to happen. But of course, she has been convicted of a horrific crime. Her defense attorney is going to do everything they can to make sure that she doesn't spend the rest of her life in prison. That is their job. That is what they are going to do. Everything that she can use to try to make sure that she is not in prison without the possibility of ever getting out is what she is going to do. So that's where we're at.
We don't know if your client has that. And the next step is, how does that affect responsibility?
Right.
And I'm not sure
she can still take responsibility for the crime
either. The next bullet point is, Ms. Schabusiness was not treated with psychotropic drugs to control or mitigate her psychiatric illnesses. He certainly, and again, I want to say, I'm satisfied that he's qualified as a pharmacologist. I'm not questioning his qualifications as that.
He's a pharmacologist? Well, if he's a pharmacologist, of course he can't diagnose her. Oh my. I didn't realize this defense expert's a pharmacologist. That's different. What you do in pharmacology is vastly different than creating the expert opinion that this defendant has a mental disease or defect that qualifies her to not be able to legally be responsible for what she has done. That's okay.
I reviewed his CV and listened to his testimony at the prior hearing, and he's a qualified pharmacologist for sure. But as far as psychiatric illnesses, again, the only thing that I've heard about from the testimony in the records is a bipolar diagnosis at Nicolay, which these other psychologists have repeated. So that
there are other assessments. They are just arguing over this one. This is going to be a battle of the experts. They're just arguing over this one expert.
The only thing that one could conclude from this assertion is that she was not treated with psychotropic drugs to control or mitigate her bipolar disorder.
How does that help you?
How does that impact responsibility? Many people have bipolar, so the next question you have is does someone who has bipolar
able to take responsibility for their actions?
Consequences be that you're unable to appreciate the responsibility in a criminal case,
and that's
that's another concern I have with whether he's going to be
going to fly.
Testify about that. The next point is psychotropic drugs do have efficacy in a large percentage of patients who take them. Well, I'm satisfied he'd be competent to testify about that.
Her being on not being on pharmacological drugs is probably not relevant at all to this, because they are not. I think it's going to be difficult for them to find an expert that says that the bipolar diagnosis means that she is unable to legally be responsible or held responsible for her crimes. It is going to be difficult for them to kind of cross that threshold, and this particular expert doesn't seem to be the one.
That I'm not sure how that actually, first of all,
how that helps you. It doesn't. That's why.
How that relates to whether or not, what she has been diagnosed with, how that would affect an individual by taking psychotropic drugs, and can he say how it would have affected somebody to a reasonable degree
I
of
don't even
certainty
think that's relevant if
used
she's
in
not
his
on
profession
psychotropic
regarding
medication.
the impact of untreated bipolar disorder? That certainly might be within the ken of your other expert. And I do want to indicate you have another expert who might be qualified to testify about some of these things, but I'm very skeptical that this witness is qualified to do so. And then the final point is that Ms. Schabusiness' use of methamphetamine worsened her untreated psychiatric condition. So really,
That's the last
issue
argument
is
they're
the
making.
impact of methamphetamine on untreated bipolar, and the impact of methamphetamine untreated bipolar on someone's responsibility to commit a crime. And I'm just concerned there as well that there's an inability
that's
to
a voluntary
connect all those
intoxication.
dots with this expert. And so while I'm willing to hear from your expert, because you've asked that, and I think the state is of the mind, we don't even need a hearing on a Dauber hearing on this, but I'm affording the defense an opportunity at 8:15 tomorrow morning. If you want to bring Dr. O'Donnell in to opine on some of this, but you need to understand that's the concern I have. It'll be a rather short Dauber hearing for this reason. This proceeding tomorrow is in the nature of a civil.
The judge is like, I am trying to work with you, but this expert is not going to be able to connect the dots that you need this expert to connect in this next phase of the trial. And that's why the court keeps referring to their other expert, saying that this expert is not the one. And there may be very negative impacts between using methamphetamine and untreated bipolar, but if this expert can't connect those dots and say, and that is why this defendant, not why she did what she did, but why she can't be held responsible for what she did. If this expert can't connect those dots, then this expert is probably not an expert the jury's going to get to hear from.
Proceeding, and I'm pretty certain the judge is not even mandated to hear testimony.
The judge is like,
do a paper review and make a determination. And so I can tell you that I've done that paper review so far, and those are the concerns that I have. And I'll want to drive directly at those issues tomorrow. I'm not going to want to hear about a lot of things that if I can testify, I might be able to say a whole lot of things. I'm going to want to know specifically about my concerns, and if they can't be directly addressed, then I would be satisfied.
Then please don't waste my time.
He's not competent to give those opinions. Even though, again, I want to indicate out of respect for Dr. O'Donnell, I'm satisfied that he's a very capable and competent pharmacologist, but I'm concerned about some of these opinions, particularly when the psychologist
he can't bridge the gap,
who would be rendering the diagnoses that he is referring to aren't even in agreement on it. Nonetheless, that's where we're at. Let me just turn to the state. Mr. Saunders, questions on what I've indicated?
No, I don't.
Mr. Frail, questions on what I've indicated?
No, Your Honor. It's very clear.
All right, very good. We'll see everyone then tomorrow morning at 8:15.
All right, thank you.
Rude. That's so early. All right. As they take the defendant out, court is adjourned for the day. No, not closing already. Verdict already. Verdict already. This case is done. All right. That's enough work for this day. This case is done. Taylor Schabusiness was found guilty in 40 minutes of all of the things she is charged with. Tomorrow, I'm going to do a lot. We're going to do a lot of Q&A right now, but tomorrow starts the second phase of the trial, the penalty phase of the trial. And that is starting with an 8:15 hearing regarding the defense experts to see what, if any, testimony will happen with that pharmacologist, what, if any, it seems like none, because the pharmacologist can't connect the dots for the court, and that's what needs to happen. Tomorrow and the next day, the hearings are not going to be whether or not this defendant used methamphetamine. that happened. Whether or not this defendant might have a mental health diagnosis, that's fine. What the hearing about tomorrow, and if you haven't watched today's podcast, I talk about it in today's podcast. What tomorrow's proceedings start with is, does the underlying diagnosis mean that Taylor Schabusiness cannot be held criminally responsible for her actions because she was not able to perceive her actions? She didn't know the difference between right and wrong. She didn't know that, yes, she was killing someone, but she didn't know she was killing someone. There isn't evidence that that is the case here yet. We will see. The defense is going to bear the burden to show that the jury should find NGI, which means that she would then serve time in a mental health facility and have generally locked, and then have the ability to be released from custody much earlier than, well, never, because that's the other option. The other option is, well, never. So tomorrow court starts at 8:15 a.m. Central Standard Time. And I said I would cover part 2. That's what we're covering tomorrow. There's not going to be a coffee and Kirsty. Do I have appointments tomorrow? I don't even know. I'm just going to be starting early. That's what we're going to roll through tomorrow. I don't know what the rest of my calendar looks like tomorrow, but we're going to make, I think it's fine. Oh, I might have to cancel an appointment. That'll be fine. I can cancel it. We're just going to roll through the day tomorrow, but the jury's going to have to come to another verdict. We now go to trial part 2. Trial part 2 is going to be NGI or not. Trial part 2. So, Dominique says either way, she's never getting out. If they find her NGI, she could get out. That is why they are fighting for it. All right. Ashley said, I've not been following. Oh, I need to do a swoop to Q&A. We have lots of questions. Of course we do. Let's just get to questions. All right. Lots of questions. Ashley said, I have not been following this. What the fuck is happening? Yeah, this is a case that'll do that to you. Yes. That is, yes. Well, now we know that we're going to cover, and we have not covered an NGI trial. I've not covered one on this channel. We don't see them a lot. They are not streamed a lot. Hopefully it will be illustrative between the difference between behavior that is completely wild, which this case is, and what NGI legally means. There is a vast difference between behavior that you look at and you're like, how does a human do this? And NGI. There is a big difference between the two, because there are cases where NGI is exactly what is needed. I don't know if this case is going to fly as one of those cases. I've seen a lot of questions about why did they let the alternates go. A lot of you asked this. Casey asked this. Stereophonics mom asked this. Others asked this as well, because this jury that decided guilt has to be the jury that decides the next phase. So they can't swap in alternates. This jury has to decide by 5-6, not a 100% unanimous verdict, by 5-6. This jury has to decide. And then I saw in the chat, Kathy's just bringing up the facts. Emily, didn't the police ask her, do you know the difference between right and wrong? They asked it in some form. I don't know if those are exactly the words they used, or if it was like, this is wrong, right? And she's like, yeah, but I liked it. Yes, they asked her, because again, that's what law enforcement is going to think when they see a crime scene like this. They're going to be like, what the fuck? And they are going to want to make sure that because they know that an NGI defense can be brought, or good detectives should know that. And they're going to want to try to answer those questions while the defendant is talking to them. So you knew that when you were strangling him, you were killing him. Yes. And you kept going. Yes. And you continued to keep going. Yes. But you knew he was fighting back and dying. Yes. But you kept going. Yes. But you knew that was wrong. Yes. But they can also, above and beyond the defendant's own statements, they can also point to the defendant's behavior. And I think that's what the prosecution will do. They will point to the defendant's behavior and say, if she did not know this was wrong, why try to hide it? If you don't know what you've done is wrong, why try to clean up the crime scene? Why try to hide the victim's body? Why try to get the victim's body out of the house? If you didn't know what's wrong, what is there to hide? Question, will there be victim impact statements? We are not to sentencing yet. So not yet. At sentencing, maybe. Will they give a new opening statement? They should. It will probably be brief, but it can vary by jurisdiction. Since she pled NGI, then why even have the guilt versus innocence? Because, well, this also can vary by jurisdiction, but the defense was arguing really hard against that count 3. 2, the defense had questioned her competency. So I think part of this was the defense saying, we're not acquiescing to anything. And then part of it is saying, look, she didn't perceive right and wrong, and she's not saying that she's the one who did this, because she was allowed to argue in the alternative. Not all jurisdictions allow you to plead both not guilty and NGI. Sometimes when it's an NGI, it's like, if you're going NGI, then you're basically admitting that you did it, but you're saying that you can't be responsible for it. So this varies by jurisdiction, but that's why she pled both NG and NGI. Are we vacationing to Wisconsin tomorrow? Yes, we are heading to Green Bay tomorrow morning. Another question about the alternatives. Do they have to stay at a hotel? No, the jurors go home at the end of each day. Can the second phase be longer than the first phase? It can be, and sometimes is. Here, I think they'll be done by Friday. That's what they expect. It sounds like the defense only has one expert, possibly a second expert that might not be allowed to testify. Sentencing tomorrow? No. More trial tomorrow. Second time. First time here, thank you for covering trial. You're welcome. That's what I do. Okie Crime News with Teresa. I do court breakdowns. Sometimes it's live court, sometimes it's documents. We love an impromptu live stream. Me too. I got home today and I was like, well, here's what happened. So I went to go see Dave Matthews last night. And I was going to be in England. I could not be in England because I am ADHD and my passport is expired. So I was at Dave Matthews last night. And as my husband and I left and were headed home today from the show, we were listening to the trial in the car, and my husband's like, wait, what about this? And Dr. B's like, what about that? And what about this? And so I was basically giving a one-person live stream over the trial. And then by the time they were asking the defendant if she was going to testify, I'm like, oh, if she testifies, I really want to talk to the law nerds about it. And then when it was closing arguments, I'm like, babe, I'm going to be home. Should we just talk to the law nerds about it? And he's like, yes, you should. You absolutely want to talk. You want to talk about this case. So it's like, after the podcast is out and after we've covered it, and now that we're past the evidentiary portion, like, yes, I really want to talk about the closing arguments. They're my favorite. So, don't lawyers go to a lot of school and get good grades? I mean, I don't know what depends on the good grades. Don't lawyers go to a lot of school? Yes, but a lot of the most prestigious law schools are pass-fail. So they're not even as cutthroat as some of the others. Emily, he would really get into a lot of trouble if he just stood up and said everything that guy just said was bullshit and sat down, right? I mean, that's kind of what the closer did in this case, but yes, he couldn't do that. Stina G in the chat asks, what number DMB concert was this? Chat, I know I will be judged, but I'm open to be judged on this because I make no shame about the fact that I am an insufferable fangirl. It is concert number 60. Jasmine said, wait, pass fail. Yes. Harvard Law's pass fail. Stanford's pass fail. I think Yale is pass fail. A lot of the most elite law schools in the country are pass fail. Some of the other law schools in the country are so fucking cutthroat. People are hiding books from the library, which doesn't really work as well anymore because, the internet, but some are much, much harder. Jolene asks, is that harder or easier? Oh, pass fail is way fucking easier. Way fucking easier. Whimsical, yes, I was supposed to be in Derbyshire today, and I could not get there because of my passport. So, Yes. They assume you have a certain level to just get in. So as long as you pass, it should be enough. I have thoughts on that too, but that's a whole ass conversation for another day. And I want to make sure I answer the questions on this trial for those that are like, just tell me about this trial. Question: is dildo a legal term? I mean, it is what it is. I would assume sex toy would be maybe how they would refer to it. I just can't with the amount of times I heard dildo in the last couple days. Well, sex toys come in a wide variety, vast and varied. So they need to be specific enough that the item of evidence, which was probably identified by law enforcement on the evidence sheet as a dildo, is exactly what it is. So a knife is a knife, a gun is a gun, a dildo is a dildo. So they are just really being specific, but that's also, if that's how the evidence is identified by law enforcement, it has to be clear that they're all talking about the same thing. So, I mean, it is what it is. Will you cover the second part of the trial? Yes, we start in the morning. Early. How much of reactions are from meds? How medicated are defendants in these situations? That was a lot. I don't know if this defendant is force medicated or not. I know that there were struggles that this defendant did not want to be medicated earlier in the trial, or not earlier in the trial, earlier in this case. I do not know. I do not know if this defendant is force medicated or not, though I will say I had defendants who were in court who were not medicated, who did not sleep well in custody, and depending on the jurisdiction, they can be up incredibly early. They can be up incredibly early to get to trial. Sometimes they are truly just exhausted. So it just depends. How does the alternates work for the NGI? Will there be all new jurors? No. Same jury will decide. Same jury has to decide. No alternates. Same 12. Question: can there be an additional charge for the lawyer charging? There can be. If there was, that would have been resolved outside of this trial because this jury would be prejudiced by hearing that. Yes, there can be. It really depends on the circumstance, but that would be handled in a completely separate case from this one. That's a great question. The court provided the report of the jurors' pictures online was false. I don't know how it came up, but yes, I heard the court say that to the jurors, that they didn't believe that was the case from the court-approved cameras. I don't know if they finished making sure no one in the gallery did that. Mara said, I found out over the holidays that my mom also watches your content and has been since 40K subs. I've been here since Debbie heard. Thank you for giving us something to bond over. We appreciate you. Thank you so much, Mara. That is incredibly kind. Huge love to you and your mom. I love that. There are definitely things that my mom and I listen to together. And what's funny is sometimes my mom will listen to my podcast and call me and start in the middle of a sentence. I was like, oh, are you listening to the podcast? Okay. Doesn't giving a statement to the police prove that you aren't competent? I don't think so. Lots of people choose to talk to the police for lots of reasons. Do I think it's advisable? Well, you can see how it goes. Like, the prosecutor side of me is like, well, it makes things much easier when you just explain it to law enforcement. The other lawyer side of me is like, you have constitutional rights for a reason. You need to exercise them. Ruby Grace in the chat asked if anyone knows if Ian went to Corey's funeral. Ian was there today. He was in pirate costume. Pepper Jelly said the fact that she said it and there might not be other evidence for the essay, isn't that the point of anything you can say will be used against you? Yes, it can be. And I think the prosecution did a good job of also saying, and it's corroborated, because she said, I used this to do that, and you'll find it here. And they did. Froggy Girl said, just got done today with my Cal State Employee Association conference. Just caught you. I will need the replay crew. Thanks for giving me something to watch. You're welcome. I hope the conference was good. Won't they need alternates? No. Guess it's just the family court in Wisconsin that gets it wrong, at least in my case. Family court is an entirely different world. We can talk family court a whole nother time. Dildo is, damn it, Abe. I'm sorry, Abe. I don't mean to yell at you in the chat. I'm not yelling. Abe's comment caught my eye as I am trying to talk about family court. I am sorry. Damn it, Abe. Dildo was a town in Newfoundland, Canada. They have a website for tourism. There is even a drinking song about it by the Arrogant Worms. This caught my eye in the chat. This is why when I record the podcast, I have to close the chat because words just jump right out of my mouth. Apologies as we're talking about how family court can be terrible. Family court is an entirely different system. It is wild, but thank you, Abe. I'm truly not yelling at you. I appreciate you. Family court, it was very relevant, Abe. It was. I agree. It was. Family court is an entirely different system, just like probate court. And it is a very difficult system to navigate. There aren't a lot of standards that make it easy to navigate. In criminal law, there's a ton of standards. It's just like the rule is this and the rule is that. There's lots of rules that are thought out and litigated over. In family court, it's much more loose, and that makes it very difficult. The family law system is very difficult to navigate. Will the other verdict be made tomorrow? I don't know. I don't know if they'll finish tomorrow. It's possible. Si es posible. I don't know if we're going to get to it tomorrow. Maybe we'll get an entire second part of the trial and a verdict. Who knows? Alternates are released all the way. Paige said, wouldn't Sarah Boone have had more luck with something like NGI with her alcoholism rather than the battered spouse defense? I would have to think about that more. It depends on whether or not, well, it depends on jurisdiction and it depends on whether it causes actual and has caused actual damage and whether she can get or has a diagnosis that indicates that. So it just depends. Question, does the jury need to be unanimous on NGI? No. 5/6. 5/6 of 12 jurors. Can't they do some type of scan to see if the brain is damaged? Generally, they can. I don't know what testing they've done here. We will find that out tomorrow. Wouldn't the defense need a medical professional? Yes. Yes, they will. And we will see a battle of the experts tomorrow. And that will be very interesting. Lori in CT said, 2 years with EDB. I laughed, I cried, I learned so much. My duty as conservator and executrix is over. Double celebration. Congratulations. And I'm so glad you're here. Out of interest, how would NGI deal with voluntary intoxication that had drug interactions that the user could not possibly have anticipated? It really depends on the experts and the jury. So when you start to hear them talking about whether the use of methamphetamine aggravated or interacted badly with this defendant's bipolar diagnosis and whether that could be a problem, then you're still in the realm of voluntary intoxication. So it looks like I owe more apologies to the chat. I am so deeply sorry. Tamara, I am so sorry. Here, I need to pull this one up too. Where is it? It hasn't popped up on my side. Tamara said in the chat that, where did it go? You said, damn it, Abe, and I got confused how you knew my dog. Abe was about to be scolded. Maybe not an apology, then maybe I can just scold Abe for you. I'm sorry. So out of interest, how would the NGI deal with voluntary intox? If it's still a voluntary, if you choose to get intoxicated and it reacts badly for you, that's not an organic disease or defect. You got intoxicated. It would be like if somebody drank and was like, I got way more hammered than I anticipated. Okay, but you chose to do that. Or you took something and it was laced with something and you're like, this had a reaction I didn't expect. You still took it though. And that's the voluntary intoxication, even if it reacts in ways that you don't anticipate. So things they don't teach you in school, but they should. If they are using the same jury for phase 2 and they already cut loose alternates, what if one can't continue? That's going to be a very big problem. Thank you for the coverage. Captain Lala, you are welcome. Do they select new alternates for phase 2? No. This jury decides. So happy you're covering this. So tired of all the guys' coverage. Well, I don't know who else is covering this. I have been missing live trial coverage, but summer is difficult with mom life. So summer is difficult with mom life. Casey Cat said, can we recognize Captain Corey's epic send-off today? Carried in a glass hearse, pulled by 2 black horses. The whole town of Ripley and Runkle and Steph were there too. That's incredible. I know that the celebration of life for Captain Corey will be on Captain Corey's YouTube channel. So when that is out, I will make sure to send everybody there and to Pixie's channel as well. Pixel said, was so happy when I saw you streaming today, and thank you. This morning we were watching the trial on LNC, and we were like, we're missing the EDB magic. I know. I am happy to cover. I know. This is the best chat on the internet, so we all love being here. I love being here. It's also Dave time. So the summer gets difficult. Between mom life and Dave life. We need to tell people to stop doing trials in the summer. Like, we're busy. We're busy. Thank you, B2. Candy said, can NGI still apply even if the psychologist found her to be competent? Yes, Candy, this is a great question. These are 2 different legal determinations. Competency to stand trial is present tense. Can this defendant at this moment in time, and they decided this on Friday, assist with their own defense and perceive what's going on with the proceedings around them? Can they understand the legal proceedings? Do they know what is happening? Can they assist their defense? So if their defense is like, wait, did you really say that? And can they be like, no, yes, no? Can they aid in their defense at the time that the trial is happening or the proceeding is happening? That can shift. So someone can be found competent for trial, somebody can found not able to stand trial, and then be medicated and then be competent for trial. So that can shift along the course of a case. It doesn't mean the case goes away. It delays the case longer. So that deals with how the defendant is at the time that the proceeding is happening. This defendant has had 5 competency evaluations, multiple competency hearings as recently as Friday. When we're talking about NGI, we're talking about the state of the defendant at the time that the crime happened. And at the time the crime happened, did they have a mental disease or defect that prevents them for being responsible for this crime, that prevents them for being culpable, even if they did it? It's like, you did it, but you didn't know that what you were doing was wrong. So it's very different. This is a fantastic question, Candy. So thank you very much, because it's a split and we're looking at different points in time. So I saw that in the chat, For the Kids said, yes, can the murder stop so EDB can see more DMB? Yes. Darren said, wow, you're still streaming. And I just looked and I was like, it's only been like 2.5 hours. And in that 2.5 hours, you know what happened? We had legal arguments, jury instructions, closing arguments, a verdict, an argument about the experts for tomorrow. We've gotten a lot done in under 3 hours. A lot done. KP Time said they only need 10 votes to deny NGI, so they could lose 2 jurors. Is that why they released the alternates? They released the alternates because this jury needs to decide the NGI, the jury that decided guilt. They can't swap somebody else in now. Let's see. So with that, kitchen knife rescue, I talked about this a bit earlier. Wouldn't attempting to hide the body be an indicator that she had some sense of conscience? Yes, and sense of right and wrong. If you're trying to hide your actions, it indicates that you know that your actions are wrong. And on a much, much smaller scale, you see this with, like, when you're asking your kid and they're trying to hide it. You can tell they know. It's like, oh, you know, because you're trying to hide it. You still playing your iPad? No. You can tell. So with all of that, y'all, it has been a very long day. I am going to be back early tomorrow. And I am going, 8:15 tomorrow Central. Sorry, moderators. Also, thank you. I have deliveries, apparently. Also, thank you. Tomorrow, we start the second trial in this case, now that Taylor Schabusiness has been found guilty. And we will see a battle of the experts tomorrow. And we will have a conversation about what the experts say. And then the jury will get to decide if Taylor Schabusiness, though guilty of these crimes, is culpable for these crimes. I love spending the day with you. I cannot wait to see what happens tomorrow. These attorneys have moved this case along. Could we get through the entire process tomorrow? Yes. Cheryl. Ew. The judge is early? You can't do that to us, Your Honor. These poor lawyers. Chat, I will be here right on time. We will see if they will redo opening statements tomorrow. We'll see what this court's procedure is. We're gonna all watch together. This court takes a lot of breaks, so there will be plenty of time for questions. So y'all, court's in session tomorrow. And we will be here with a NGI trial starting in the morning. So 8:15 a.m. Central Standard Time. I'll see you tomorrow. I'm gonna go get some dinner and hang out with the kiddos, and probably play a little Breath of the Wild or Tears of the Kingdom, one of the two. I'm gonna go play some Zelda and get a good night's sleep. It might be one day, it might be two, but I think we'll be done by end of the day Friday. So, question: from what time are you streaming tomorrow? I will set the stream for 5 minutes before court comes in. I will do my best to be right on time. So I am going to set the stream for 8:10. I'm really gonna do my best. It looks like Natalie Lawyer Chick is about to see a stream, or start a stream, so you guys can head on over there if you like. Did you see the video of her attacking her previous attorney? I did see that, and her hands were shackled to her waist, so she couldn't get too much done. So, question: can she testify in this phase even though she didn't in the guilt phase? Yeah, the guilt phase is over. She can. I don't know if she wants to, but she can. So with all of that, y'all, thank you for being here. Thank you for being law nerds. You are the best. Thank you, Gringa Latina. I appreciate it. And cheers. Take care of yourselves. Take care of each other. Try not to read too much about this case. The facts might stick with you for a little bit. And we'll see you tomorrow. Tomorrow we'll be able to kind of more neutrally talk about the facts and talk about I hope we get some neuropsych testimony. Truly, it'll be really interesting. And with that, I'm going to say goodnight. Bye, everybody.
You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at the Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.